For another 10. We are on? You're pulling video? I know. Technical difficulties. One of the servers on the company we're using, their timing was off. And so when people were logging in and they hit that server, it said this event took place 10,000 hours ago. So they were kicked off. And so now my office right now, the girls want to strangle me because we received about 150 calls from irate people. You took my money and you're not providing the event. And then the gals turned around and they said something, oh, don't worry, it's recorded. You can see it later. Why do you want to watch it live? It's like, well, that's not what you wanted to say. But things happen. So we're just going to wait, if you don't mind, another 5-10 minutes because I still see people logging into the room. It really shot up the last, because I get all the emails in the last day and a half, actually a day, by about 250 people. That broke my email system. So they're there. I just want to make sure everybody gets involved. What we could do while we're waiting for it formally get started, if there's any questions anybody have, we'll do a Q&A. Are we getting started? Nobody wants to fess up yet? Okay. No? Yeah. We're going to be the first ones there. See? Right on. See, all from the local area, I take it. Yeah. You're not?
Washington State.
Really?
Yeah.
You flew down here just for this?
No.
Oh, wrong answer.
I'm down here just to get out of the rain.
I know. Yeah, it's nice today.
Is it?
Yeah.
Yeah. Here?
Yeah. Well, no, it's back in Seattle.
Yeah. Here?
Yeah.
Nice yesterday, too.
Here?
Yeah.
No, nicer you ever back.
Yeah.
When I flew in yesterday, I was shocked.
Yeah.
I was expecting it to be sunny.
Weird.
Yeah. Great. Where are you from? Oh, okay. I've got paperwork for you to sign. Okay, so we'll meet afterwards. You drove up from L.A. We still have the gloom. I was in L.A. last week, and the gloom was all over the place. Is it dissipating yet? Okay, that's good. Yeah, nice. So we have Greg. I don't know if you've met Toby Mathis. For those of you that have set up any docs with us, he's the individual who's on your LLC as the nominee manager. Some people ask, is that a real person? It is. Yeah. There you go.
We're in good shape. Are you in Seattle?
We're in Tacoma.
Okay.
Yeah.
I'm in Longview.
Okay. So you're south of me. Yeah. Familiar with that area. I remember when I was in high school, we went down to Kelso, play a football game. You did? What year? Okay.
5 years ago.
Yeah. A little before my time.
Did you graduate from Tacoma?
I never graduated. Yeah. I quit after the 7th grade. Figured why. Yeah, well, I mean, you know, I got my law degree online from some university in the Cayman Islands, so it worked out well. Yeah. I did it in 3 weeks.
It didn't work out well. You should have been there in person.
Yeah, that's right. Where did I graduate? Seattle University. Yeah, so I went to law school. I did my undergrad at UW after 2 years at Washington State University. It was a hell of a good time. Yeah. Well, oh, yeah, well, yeah. First semester, 1.6 GPA. Yeah, too much drinking. Did you? You me? No, I had to come back. My father told me if I wanted to screw off like that he wasn't going to pay for my education. So I stayed out of that area. I got a job and worked full-time and then went to school part-time, or full-time, actually. So, how are the numbers looking?
They're still back there.
There's. Have Steve call him again. I'm going to start in 4 minutes. Technology. There's going to be another player in the game. Anybody on that webinar? Who's on the webinar? Okay, that company is actually putting together something in high def, which is going to compete with the company we're using right now. And hopefully it'll be less expensive and better. We'll see.
That for live video streaming or
For live video streaming, for what we're doing here, Omnovia. Presently we're using Omnovia, but GoToWebinar is putting together their own streaming video, which is something that would be nice.
my son works for Internet Technology.
Yeah?
North Carolina, but they're evidently a major player in the online video
Okay.
streaming, and they just got bought out by Cisco.
Oh, so Cisco buying up because they don't want the competition?
Well, they needed the platform.
Yeah.
They have all the software and the hardware.
Nice.
They're, I mean, they only, it was a company of less than 50 employees, but their clients were like Major League Baseball and ESPN and the White House and UN and anybody that wanted to do live video streaming.
I'll go through them. Well, it's a wave of the future because people don't want to travel. Travel's expensive and a hassle. So if you can watch it this way, it works.
Isn't that what they want? They don't want us to travel anymore.
Yeah, it seemed that way.
To go to webinar,
Mm-hmm.
that's the same company, go to meeting.
Same thing. Yeah, it's different sides.
They see airport security on the street.
Yeah,
Coming to a town near you soon.
think so.
Why not? It's going to be everywhere. They don't have funding for what about 30, 40 airports?
Oh, the full body scanners? Yeah.
A friend of mine owns a manufacturing operation in Portland, and they've been shipping these trailers to the feds for the last year and a half that are designed to close up the highways. I got bad for it, and they ship 1,500 of them so far.
Wow.
Civil unrest. That'll be fun.
Yeah. All right.
Yeah. I don't know about you have to cram it all in 2 days. Yeah. Because the guy that said the world was ending in 1980, he's called it out again tomorrow.
All right. It's working. Really?
When I try to log on,
So still having problems. Tell Steve to give another call, will you? And then do that. Okay. So really, no questions up for me on anything. You have any questions about any of this stuff?
well, yes, okay.
All right, hold on. Let's get to we'll get this one, all right?
No, I can speak now.
Well, yeah, but the camera can't pick you up.
Oh, the camera.
Yeah.
Well, this has to do with foreign currency. We know that there's been some question in terms of the dinar that Anderson's position was that when it revalues, it'll be revalued as ordinary income. But from every attorney that I've spoken with, tax attorneys, accountants, it's a long-term capital gain versus short-term capital gain.
Mm-hmm.
And
That's
yet,
our position.
well, that wasn't the position that was given to us the beginning of the year when we came to one of the workshops.
One of our workshops?
Yes.
Well, okay.
And Steve conveyed the position of the Anderson Law Group to us at that time.
Here's the position of the Anderson Law Group. Plan for short-term capital gains. But if you've held it for more than 1 year and you can verify that you've held it for more than 1 year, I think you should claim for long-term capital gains. Now, what is our position following the RV? We're going to get a private letter ruling to determine whether or not it's short-term or long-term capital gains, how they would approach it. The default presumption that people have told me is that, oh, it's all going to be default long-term capital gains. You're fooling yourself if you think it's going to be default long-term capital gains. The IRS will presume that it is short-term capital gains, which is ordinary income to you, because of the fact that they're going to generate more tax revenue from that. So I believe that you should put 35% away, plan on 35% taxation on the currency. Be conservative in your estimate. To come out and just say it's going to be taxed all at long-term capital gains, I think is, misleading, and it might hurt you in the long run. So if you plan on 35, because who knows what they would do in that situation. If they would say that it was purchased not for investment, but to capture short-term market swings, therefore it's not an investment in the long-term capital asset realm. That's the unknown. So I'm not going to tell people that, oh yeah, it's guaranteed 15%, because if it's not, you rely upon it and you don't save, then you sue me.
But if you hold it for over a year, it's a long-term thing, right?
Huh?
If you hold it for over 12
That's the way I would claim it on my taxes. I would list it as long-term capital gains if you held it for more than 1 year.
But what if it RVs and you haven't held it for that long? You
Plan on 35%.
Well, plan on waiting before you cash it in.
You can do that, but I would just plan on 35%. Make it in your mind, because this is where I see people get into trouble before. When we were actively involved with stock traders, people who buy and sell real estate, they never plan adequately for their taxes. They don't put the money aside. Then they end up not paying their taxes the following year. And there's this snowball effect. If you plan for more than what you're going to owe, you're always going to be covered. And I think that's the safest route. And what we're considering here with the amount of income it could generate for us, I don't think that's too much to consider, putting that type of money aside.
Just one more question. I hold a significant amount of my dinar in an IRA.
Mm-hmm.
And actually it's been, I did a conversion last year, 2010, into a Roth IRA. So I have a tax basis based on the value at the time. My concern, we're hearing rumors that the IRS is planning on taxing us at the cash-in event. Now, in terms of an IRA, a bank cashing in for you in an IRA where it's in a secure investment, like not investment, but a vehicle like that, we don't have any concern in terms of there's no tax liability to us at this point in any case, as far as I know, because it's in an IRA until we take it out of the IRA. See, the banks will then cash in for us.
Okay, this comes up a lot.
Okay.
I hear what are called rumors from several people on a daily basis. And the thing is, unless you can validate it, just take it with a grain of salt. And I wouldn't put any credence in it. I always tell people, show me the law. Show me whatever it is you're relying upon, issued by the Treasury Service and whoever it is, and then I can give you an opinion as to it. But I'm not going to address, well, I was on this call last night and Joe from Montana said this. What do you think, Clint? I don't even respond to those emails because it means nothing to me. Yeah. Hold on, let's get that mic back there.
Following the RV, will you be putting out a procedural document once you find, because you're right, rumors are flying. So you put out something that says this is the cash-in process, this is what you should do, this is what we recommend, et cetera, et cetera. So they're talking about banks, they're talking about issues of revenue wire transfer. I mean, all kinds of things are coming up.
Well, where that comes up is that it's the unknown. We don't know how it's going to be treated from that standpoint. So what would I tell people? Well, I'm going to share with them my own experiences. And that is when at RVs, first thing I'm going to do is take all mine down and I'm going to go cash it in. And I'm going to go down to most likely Wells Fargo and see if they'll exchange it. And then I'm going to go to a different bank and see if they'll exchange it. Now, I know there's Ty and all the others said they're going to set up their own spots where you can go and exchange it. That's fine. You're free to go there. I'm going to a bank. I don't care if I have to pay more. I just want to make sure it's a seamless process for me in dealing with the bank where I have accounts and so I can move money over. So that's what I intend to do. Now, from my own experiences, I will share that with individuals. But right now, at this point in time, it's pure speculation to say this is going to happen after at RVs when you try to exchange the currency. I can tell you this. I've heard from people that they were going to exchange their currency for gold. What are you going to do? To have $10 million in gold, bring a truck and have them load up gold and silver bars in the back of your truck, and they're going to have that type of gold available at their facility? That's unreasonable to even think that. And it does concern me when somebody even makes a statement like that, because I think it's preposterous that somebody, a company would be able to hoard that much gold. Where did they get the money to buy it? So from that standpoint, what I'm going to do is share with everybody my experience and what I learned. And that's just, it's no different than how we operate when it comes to the, for example, real estate, because we work with a lot of real estate investors. And the market's always changing, and so we're always investing in real estate. And so I always explain to them, here's what I've been experiencing. You're probably going to experience the same thing as well in your own investing. So I think you got the point that I don't know for sure what's going to happen, but I do not place any stock in the rumors that the banks are going to do this, and this is what's going to have me try to transfer the funds over, that the IRS is going to take the taxes right away. If you RV half your currency, you're going to pay tax on all of it. I've heard that before. My response to that question is, how do you know how much I have? So where's this? Is there now a special form that's going to be created where I have to disclose all the currency? That's new to me. I don't think the government is enacting special rules and regulations just for the dinar. I don't think their eyes and their focus are on the individuals who have invested in the dinar, and they're thinking of them as potential tax cheats. So I wouldn't think that we're on any special radar screen no more, though, than anybody else that's investing in the stock market or in foreign currency traders in general.
Does it matter where you got the dinar from? In other words, I can prove my paper trail of when I got it, but it went through some private individual hands. Evidently, it came from a bank. Evidently, it came from a bank and then went through some private individuals' hands before it got to me. Does it make a difference that I can't prove that I got it directly from a bank or a dealer?
Does it matter if you can't prove? I don't know how the proof of where you received your dinar is important, but for holding periods, it would be important. If you claim that it was long-term capital gains, you've held it for more than a year, then I think you could you might run into a problem if you cannot prove when you acquired it.
Well, I can prove that, like when I wired money to somebody's account, but it was to an individual.
That doesn't prove anything, other than that. I mean, that's further evidence in your favor.
Right.
But did you receive a receipt from that individual?
Well, I can get the receipt.
I would get the receipt then.
Okay. Thank you.
Yeah. God, there's something else I was thinking on that. Escapes me. Yeah.
Along the same line, for some who have acquired dinar in 2007, 2008, nobody was thinking receipts and things of that nature at that time. We sign our income tax returns that this is true and valid, and we don't have it notarized, and et cetera, et cetera. Could we, I can show a paper trail at a point in time when I started buying large volumes of dinar. But when I'd buy 1 million or 500,000 or, from here and there, there's dinar that I have no record of. Would a sworn statement and having that sworn statement notarized suffice for the IRS?
If I understand your question, you're asking me if you have a sworn statement that you signed.
Yes.
Is that sufficient for the IRS?
Would that be? In other words, I have a record of X number, just a hypothetical figure. I can track where I bought large volumes, 100,000, 100 million dinar.
Yeah.
But I had a couple of dinar prior to that.
The problem is we can't get in your head to verify that information. So you can swear all day long, but the fact of the matter is they're going to want proof.
Yeah.
And absent the proof, because think of it this way. When people file a tax return, they say, they state on their return, I spent $10,000 on business-related expenses this year. They're audited. They can only produce receipts for $6,000. There says, well, where's the rest? Well, I lost them, but believe me, I swear to you that I spent that money on business-related expenses. They don't say, well, just sign this paper that you swear, and we'll give you them. Yeah, so it requires documentation.
Directly relating to that, I've given some of those early dinars away, like in 2009 as Christmas gifts. And I signed over a document and had a witness sign and date.
Yep.
For them, they have it, that's the date. I don't need to prove that I bought it somewhere before that date.
Nope. It's theirs.
Yeah.
Yeah. Craig, how are we doing? I'm going to get started now.
290. It's just inching up very slow.
Okay. Well,
He's on the phone with him, but everybody can hear you fine now. And the only thing I ask of you guys is when we do have questions, if you can hold the mic up because they are having difficulty if you're not holding the mic up.
okay.
But yeah, there's 290.
Well, we'll get started. Just the black button on the mic itself. No, right up on the handle. On the handle. Just turn that one down. That's it. And then you flick it up. And okay. That's probably why we had technical difficulties today. Were you involved with the system at all?
Other than leaving it in your hands, I thought it was best for on full force. I'm sorry.
Yeah. All right. So as I stated, this morning, for people that are just logging in, if you tried to call our office, our server went down last night. 2 drives crashed. It took everything down with it, and they had to rebuild the server this morning. Our phones run over the internet, so when you lose your server, you lose your ability to collect emails, you lose your ability to make phone calls, and so for a while there this morning, nobody could reach it. But that's all back up and running now, so our office is available, as people know, since they've been calling. I want to thank you all for coming. For those of you on the internet, I'm glad that you're able to log in. I know it was a bit of a difficult process getting on today, and I know some people are still going to be joining us, but technology, they're working on it, and I expect that everybody will be good to go here within the next 20 minutes. So I do have a question. On my way up here, I found a roll of dinars with a rubber band around them. Good. Here's your rubber band. See, I always want to be a joker. There you go. What do you expect from an attorney, though, right? So anyways, those of you that, I know there's a lot of talk about the RV. I've been talking to Dan, or as some people know him as Checkmate, and he told me that it was supposed to happen the other night. He'd been hearing a lot of things, and same with this weekend, possibly, or today. So if you're wondering, I am carrying around some of them right here just in case it happens. You can't leave home without them now. I told my wife before he came down here, I'm going to take some with me. She thinks I'm crazy anyways. But, you just never know. So, see, for those of you who've been on any of the calls before and we've discussed this, my approach or my thought process when it comes to the exchanges, I'm going to exchange everything I can immediately. I'm not waiting. I look at it as an unstable country to some extent, and currency fluctuations in general for my clients who trade in the stock market, trade in currency markets, so I'm all in. If it came out, I had a dream the other night that it came out, it was a scary dream, it was a nightmare. Actually, it was revalued at 7.5 cents. This was on Wednesday night, right before I was flying down to Vegas. They're right on my nightstand, and I woke up. I said, I don't know. But I know it's still not a bad return on your investment. You can't complain with it. I've told people that. If even it revalues for a dime, I'm happy. I made $50,000. I can't complain at that on a $5,000 investment. So whatever happens, I know I'm going to be blessed, and so I'm looking forward to it just like everybody else. Now, this event, what we want to do here is expand upon some of the information we've told you in the past, answer a lot of the questions that are out there to understand how the entities work, and more importantly, why the entities are so important. And that's what I'm going to do this afternoon. I'm going to explain to you what some of the threats are that we all face, because from a liability standpoint, people don't necessarily realize it. When I talk to individuals and I explain to them that you have to look out for things, you have to look out for attorneys and people in general, that they might want to take your money, they look at me like, well, I've never been sued before, so I don't have to worry about it. Well, you cannot predict lawsuits. Similar to estate planning, you cannot predict when you're going to pass away. So these are things that we have to keep in the back of our mind and understand where the threats lie. So we're going to cover that today. I'm going to cover some strategies today. And then tomorrow, what we will do is break down some of these entities in detail and talk about the operational aspects of different types of entities and how they should be utilized after the RV, and things you need to be thinking of as the questions were brought up about what you're going to do with your currency. Because we get a lot of questions on that. And so that's what I want to focus on for a day and a half. I'll be speaking. Greg will be speaking. Possibly one of the other attorneys will be speaking. For those people who are on the internet, because they cannot ask questions directly of me, we have it set up where they can just ask questions. I have a few people, attorneys on the line. They'll be answering your questions. And occasionally, Greg, for those of you in the room, he will ask me a question from individuals that is on topic. And that's why when I say this, that if you're listening on the internet, keep your questions of what we're covering. Sometimes there's a tendency to jump ahead in the material. And that's the same with the class as well. If I'm not talking about a charitable remainder trust, just kind of hold that question until we get to the charitable remainder trust section and just see if it doesn't get answered during that time, because I don't want to throw it off the presentation, the flow. So with that, we're going to move right into this presentation, unless this decides to freeze on me as well. All right. So who is Anderson Advisors? Well, this is a little bit about our firm, for those of you who are not familiar with us. This is one of our offices down here in Las Vegas. This is our boss office. This is our nexus to Nevada. So when people set up a Nevada-based entity, we have to provide a physical address for that entity. We provide it out of this office right here, this office building. In this office building, we have a tax department, which when you came in here on the second floor, you notice that was the tax department on your right-hand side. You didn't see in there, but there are CPAs in there. We have attorneys downstairs for Anderson, and we have support staff all throughout the building in different areas, operating, doing different things. And business plans take place in one area. We also do some business credit for individuals. So we do a lot out of this office. We have down here approximately 30 employees in this office in this location. And we also have our main office. I call it the main office for Anderson. Is in Tacoma. It's in some of you don't know where that is. It's south of Seattle. And up there we have approximately, what do we have now, 9, 10 employees, and 10 employees in the Tacoma office. Why is this office down here bigger? Simple. For the same reason why people do anything when it comes to asset protection or business planning, taxes is always an issue. It used to be that our office had 50 employees, 40 employees up in Seattle. And the state of Washington thought that they could take a big chunk out of our revenue. So we said, rather than pay you more than what we're earning, we're going to actually move the business down to Las Vegas. And that's why we saw this shift over the past 5 years of moving more of our operations down there. We've kept a portion of it in Seattle or Tacoma because that's where I live, and I don't want to move down here. My wife won't move down here. So we have 2 offices, 17,000 clients thereabouts in 50 different states. Most of our clients come from workshops like this, where we will actually go out and put on a workshop and meet with individuals on a one-on-one basis. We've been successful at that because the information we provide, I think, is unique. It's hard to find this information from local attorneys. When you typically walk into a local attorney's office and you tell them, hey, look at this currency that I have. This is going to revalue, and I plan to make $1 million, $5 million, $6 million off of it. What type of response are you typically going to receive from an attorney? Okay. Now listen, there's a place, a psychiatric ward down the street. I want you to go visit them on your way home. You don't need my services. You need to go talk to this gal. And then a lot of attorneys treat their clients in that manner, that they don't understand what it is they're doing. So if they're not up on it, they're obviously down on it most of the time. And I've seen that just in my own dealings with attorneys. They often have a tendency to talk over the client and not listen to what the client is telling them, because the attorney feels that they went to law school, therefore they know it all. And that's really helped our firm out when it comes to dealing with investors of all sorts. So what else we work on? Tax, as I said, asset protection. That's pretty much us in a nutshell. I mean, this is what we do. We're investors. Those of you who've heard me talk before, I'm a real estate investor. I've been doing a lot of investing down in this market right now, the Las Vegas market. But we've also invested in several other states. Business owner, stock market investor. I've done a lot in that area. Made some money, lost some money, and you learn things along the way. And so that was a previous question, about when it revalues. How am I going to know exactly what the process is? Because I'm going to live the process. I will go through the process. And most likely what I will do, and when I tell you that I'm going to exchange it all right away, I will. And I will go down to Wells Fargo, but I'll probably go to Chase, and I'm going to go to Bank of America, and I'm going to go to some different institutions and see how they treat the exchange, so then I can report back to individuals my experiences, because I know a lot of people are going to be holding on to their currency, maybe going out to San Francisco and not exchanging it right away. So at least you have my basis in understanding how it worked for me, because just as what I'm going to be telling you today, how you should hold it, is how mine's held. Even though I have physical possession right now of the dinar in my suit pocket, it's actually owned by my limited liability company because I ledgered it over into the LLC. But it's a currency, it's paper. So who holds that? Well, Clint does as the custodian. So I hold this on behalf of my company. It's similar to, a car. If you drive a company car, well, what makes it a company car? If you're driving it, it's the fact that it's owned by the corporation. Even though it's in your driveway, it's still a company car. So it doesn't necessarily matter where that asset is located, provided how it is titled makes all the difference. And so that's what I'll be looking at it, as we said, when the currency exchanges and what I'll be doing. So we'll impart that to everyone. All right. Now, education, pop quiz. For anybody that wants to deduct education after this, I put stock trading education, but really what it comes down to is this. If you invest in any type of education after the RV, because I assume many of you are going to want to go out there and look for other opportunities. Is that true or not? I've heard a lot of people tell me they want to invest in the stock market. They see that as an opportunity for them. What you need to realize, and this is a post-RV question or a post-RV strategy, is that I've talked always about pre-RV. Set yourself up this way, and we're going to focus on that as well today. But post-RV, one of the entities that we haven't talked a lot about is a corporation. If you don't already have one, as soon as the currency revalues, if you want to write off this education, because as individuals, you're not going to be able to write it off. Okay? You're not going to be able to write off any type of education. If you want to get involved in real estate, it's going to be non-deductible education, because I know a lot of people have told me, Clint, I tend to go out there and buy and sell property. Well, the biggest mistake you can make, and this is coming from somebody who's a real estate investor, is to go out there and buy and sell property without understanding your market or how real estate works. And the best way to do that is to get education. Well, if you have money from the RV, you don't have to recognize that in income taxes until you pay your taxes on April 15th. So if it RVs this weekend and you exchanged all that currency, your tax is due April 15th because you didn't have that same type of income the previous year. Therefore, you're not going to be hit with taxes immediately. You won't have to pay any quarterlies on that revenue stream. So the question is, how do we reduce our tax liability after it RVs? Well, you spend money, but you spend it the right way. You do not spend what we often refer to as after-tax dollars. You want to spend pre-tax dollars or revenue that creates a tax deduction for you. So if you're considering strategies, how to plan for this, if you're not going to cash everything in at once, I would consider setting up a corporation after the RV. And then for any activity that you're going to engage in, say it's education-wise, stock trading, invest in real estate, or other education that's out there, I would place some of my dinar into that corporation, and I would exchange it through the corporation. Generate some cash in that company. Now, why would I want to generate cash in that company? I can tell by somebody's look on their face right now. That's income to the company. Companies have to have expenses. What's going to be one of your expenses? Well, if you're going to go out there and invest in education, that is an expense you would deduct on your corporate tax return. So I would set up a C corporation, put some currency into it as the initial funding of that. Your company should be, the business purpose of that company would be to manage investments. It would be managing your limited liability company in the future. Most of the companies that we've set up at this point in time, LLCs, we've nominated an individual as the manager. So you see this for many people. We have an LLC that's set up with currency inside of it. And we have an individual up here listed as the manager, a husband and wife. And then you're down here or your living trust, which we'll get into. Now, for this point in time, this is, I think, a great strategy for what you're holding. But after it RVs and you bring on your corporation, then what I would do is replace you with a corp. And we're going to cover more of this later on. But this is something that this plan will morph into more than what it is today. So when we're talking about what you can deduct, stock market education, training, what you want to know is that, you're not going to be able to write it off. I mean, this comes up a lot too, traders. Can I claim trader tax status? I see people who've asked me a lot of questions like this. These are questions I've got from individuals who've been peppering me that are interested in trading the stock market. And maybe it's because we're invested in the dinar and they think they can write it off. As an individual, you can't. You cannot trade, make a bunch of trades, and write off that expense. It just will not happen for you. Another example, insurance. How about if I buy insurance? Will that protect me from lawsuits? Does anybody believe that? No. Why not? Has it ever happened that you've had to make a claim under an insurance policy before? Try it and see what happens. Many times they're going to fight you when it comes to insurance. There's a sad story of an individual that contacted me about a month ago. He's a referral. He called me up and said, Clint, I was referred to you by so-and-so, and I need asset protection immediately. How fast can you set this up? Actually, I needed it yesterday. All right. Now, when I get a phone call like that, little buzz alarms start going off in my head. Why do you think that is? Yeah, because the liability horse left the barn some time ago, and he's been running around the track. And now what this individual wants me to do is go out there and grab that horse and put it back in the barn. I cannot do that at that point in time. In fact, I'd be assisting them in committing a fraudulent transfer, so I cannot help him. Now, this guy that came to me, medical professional, and the reason he was seeking my assistance, because he was out on his property. He has a rental house that he was working on, and I'm going to call it his brother-in-law. If you had a common law marriage in that state, it would be, this person would be considered his brother-in-law, was assisting him on this rental property. And he was up on a ladder doing some work on this house. Well, the person who called me, the doctor, he was in the backhoe, digging and moving the bucket around, and as he moved it to the left, hit the ladder. What happens to the guy on top of the ladder? Humpty Dumpty fell off the wall, and he didn't get back up. He died. And as a result of that, of course, this individual is involved in a lawsuit. Well, he told me he wasn't. He said, I'm not being sued. It's my insurance company she's after. She told me she's not going to sue me. That's the so-called sister-in-law. I said, well, in order to get to your insurance company, she has to sue you. You can't just sue somebody's insurance company. So if you look at your complaint, you would find you're the defendant. He goes, all right, so I guess I am the defendant. But the problem that he was facing is that his insurance company, both insurers, the insurer that he had for his contracting license when he was out on this property and his homeowner's policy, were denying coverage. And they'd filed a declaratory judgment in federal court to block having to cover him up to his limits in this particular case. Now that's frustrating, and it's very disheartening for an individual, as he stated, who's been paying his insurance policy for the last 15 years, been with this company, never made a claim, and the first time he does, they elect not to pay out. And he stands to lose everything. And he told me, he goes, I've worked hard all my life. I'm in my 50s. I want to think about retirement. And now I'm looking at a life of continued work because of what this case is going to do to me. And he wanted to know, he goes, what happens if they're successful? I said, you really don't want to know that answer right now because it's going to depress you even further. Because if they get a judgment against you, that will follow you around for the rest of your life. And that's why you need protection. So insurance is most likely not going to protect you. And we'll give you an example of that as we go along. How about this? Borrowing from your IRA to fund a trading account or just from anything in general? Think you can borrow from your IRA? You think you can contribute dinar to your IRA? You think you can contribute dinar to your IRA? Be careful. Be careful on that one. For an IRA or a pension plan, it requires that you make cash contributions. Cash contributions are required in order to fund these types of plans. Now, whether or not foreign currency in the dinar would constitute a cash contribution, I don't think so. It would not, because you bought that as an investment. So now you're contributing an investment to your plan, therefore is a prohibited transaction. So if you have a Roth IRA, you have a regular IRA, you have a pension plan, be really careful with funding those, because I've talked to probably 15 people who have told me that they're not going to pay any tax when at RVs because they set up a Roth IRA last year and they put all their dinar into their Roth IRA to make their $5,000 contribution. Why are you looking at somebody in this room?
because I commented on having, what I did was
Wait, now, this is being recorded. I don't think you want to say that in this room. Okay? All right. We'll just take it at that. So the answer to that is false. All right, this one. Here's a question. A will, does it avoid probate? Yes or no? No. Does anybody here have a will? You do. What's your name? Ron, that's right. Ron, do you have a living trust as well or just a will? Okay, anybody have just a will? That's all, nothing else. Just a will. Why? Okay, is it a good will?
Not anymore. I got married 20 years ago and I'm divorced.
Okay, so that makes it a bad will. I understand. Brings back bad memories, huh? Okay. A will does not avoid probate. Many people assume that if they set up a will that it's going to avoid probate. And one of the things that I've commented on a lot when it comes to this currency, holding this currency, this is not something that you want to go through probate. Because on a number of different levels. Number one, how is it going to be treated? How is it going to move from you to your heirs? Have you specified to whom is going to receive this currency, how they're going to receive it? Because I'll tell you what, I've shown this to some people before who knew nothing about it, and they looked at it as if they would take that currency and give it to their 2-year-old as a gift, just to play with. Here, go play Monopoly with this. It'll be fun. And so keep that in mind when you have this type of asset. If you haven't necessarily provided for it, and you don't have an estate plan in place that specifies what's to occur should you pass away before it RVs, I mean, I think it's an opportunity lost. And a lot of people who have just planned with the will and it doesn't address this, I think you're missing something there, and that's something you need to seriously consider. So will in and of itself does not avoid probate. It's going to put you in the probate process. Probate is something that should be avoided. It's not somewhere you want to be, because then you have somebody like myself and the court system determining for you what's going to happen with your estate, because they're involved. It's a public record, so all that information is disclosed to anybody who wants to find out what it is you have in your estate and how much you're worth. You know, if I was thinking, if I was going to be a robber, okay, now you're probably looking and going, oh, you're a lawyer, right? So, but we can legally steal. No, on the other side. Okay, I went to law school for that, right? So if I was on the other side of the coin, maybe I just monitor probates every month. Who died this month? Because when you monitor probates, they have to submit a final accounting to the judge. And so you get this final accounting of all the assets that Grandma had when she passed away. And if it lists all this jewelry and all this furniture and all these televisions and all these other fine assets, well, where does Grandma live? She lives in that house. So if I go there, I'm going to find these paintings and all these nice works of art because they were disclosed to the probate court as being an asset of the estate. So if I was trying to figure out which house to knock off, I'm going down to probates, managing those, looking through those records to find the nicest looking record I can find and then go hit that house because you know nobody's living there. They died. So that's one reason why I would suggest that you avoid probate, especially if you own property. This is something that's typically not disclosed. You own property in more than one state, you get to go through 2 probates. You own property in 3 states, 3 probates. Everywhere where you own real property, and this is something people told me that after at RVs, they plan to buy a house here, another house here, maybe a 3rd house as well. Well, if you own all that in your own name and all you have is a will and you haven't done anything else, or you don't even have an estate plan, there's multiple probates that are going to be set up for you there because you cannot probate property out of state, real property. So that's always a problem. Clicker's not working, so false. All right. So how do you define asset protection? Because that's part of this event. What's that? Hire a good lawyer. Hide behind your lawyer, Ron says. That's how you define asset protection. Okay, I'm all about hiring the lawyers. I agree with you on that. Okay? Maybe you should have 2 or 3 that work for Anderson working for you. Even better, right? Triple the protection. But, I mean, really, besides the law, when I say asset protection, what comes to mind? Yes. Ron says LLCs. You say trust is another one that comes to mind. So we have entities. So we're talking LLCs, trusts, corporation is asset protection. Well, what are you looking to protect? We got the tools to do the protection, but what are we actually trying to protect here? We say assets. But how do you define assets? Because this is where most people, I think, sometimes miss what is meant by assets, what is really defined by assets. Okay, so you say cash. Real estate. How about anything you want to protect? Right? That's an asset. Anything that's of value to you. Now, so we have cash, we have real estate. How about the dinar? Is that a value to you? All right. Okay, IP. Any other ideas of things of value that you want to protect? Vehicles. So we have cars that we want to protect, SUVs, things like that. Businesses, that's good. So you want to protect the business. What do we find on this slide? We find assets that we've spent money on, that we've spent time on acquiring, and so we place a significant value on these things. We place a monetary value. And when we think of asset protection, most people who come to this event initially think of it in terms of these types of items. And I agree with you, to some extent, that is important. But I think it's more than that. And I think when you look at asset protection, I'm going to show you how I define it. Okay, this is a picture of my family. I'm going to personalize it a little bit. When I think of asset protection, it is my family with whom I think of. And so everything that I do, from when I get up in the morning to when I go to bed at night, a lot of what I do, the planning that takes place in my life, is devoted to planning for my wife and for my kids. Because when I got married, I told my wife that, I wanted her to stay home, to be a stay-at-home mom, and I would make sure that she could do that to raise our kids, which she's done an awesome job. My kids get straight A's, and I attribute it all to my wife because she's been there. She's been that rock that they have because I travel. I'm not here all the time. And I don't want her lifestyle to have to change. If something were to happen to Clint, like, for example, when I was flying in here yesterday, it was bumpy, and the guys sitting next to me, they're, and I looked over at him, and I probably wasn't the right thing to say, my wife said. I said, I go, it's always bumpy flying into Vegas. And he said, not this bumpy. I said, no, it can be. You're lucky the plane isn't doing this or doing the fishtail as we're coming in. But at the end of the day, we don't have any control over what's going to happen. Okay? We're not up there. So relax. He's looking at me and goes, what do you mean relax? I said, if we're going to go down, we're going to go down. And there's nothing that you're going to be able to do about it. So why make your last minute stressful? He turned, he wouldn't talk to me after that. But some of it, I'll tell you what it comes from. Peace of mind. You start thinking of your family and are things put in order for them? What were to happen to you tomorrow, or if something happened today, what's going to be left for them tomorrow? And so I look at asset protection. When I put together LLCs and I put together a living trust, it's with them in mind. When I buy life insurance, it's with them in mind, so that everything is spelled out for my family so that they'll be taken care of. And literally, that's how I view asset protection. Yes, the assets are important. I protect them, but I do it for a different reason. I'm not so concerned about, I am concerned about creditors, but I'm most concerned about protecting it for my family. So that's why we do it. Because if you're ever involved in a lawsuit, this is what it's going to feel like right here. You're going to feel as if somebody has taken a gun and has put it right in your face when you open the door. Now, it's not going to be an actual gun. What it's going to be is a summons and complaint that is being filed on you. And at that point in time, I can guarantee you, if you've never been through this procedure before, everything in your life, you heard of tunnel vision, it's going to get black at the periphery. And you're going to be looking at that paper, shaking your hands, you're going to sweat, you're not going to be able to sleep at night. You're not going to be able to sleep for weeks, if not months, because of the uncertainty in being involved in a lawsuit. Has anybody here been sued before? You have? What do you think?
Well, I won. It'll consume your life.
Okay, so you say that you won and it consumed your life. That's what it is. That's the worst. That was probably the worst part about the lawsuit, was the fact that it took over your life.
Right.
The money is an aspect as well, because you have to hire an attorney, and do they come cheap? No. Is the attorney typically walking into your lawsuit saying, tell you what we're going to do. We're going to have this settled for only $3,000, and I'm going to work hard to get it over with right away? Well, let me tell you something. There are a lot of issues that we need to explore here. Sure, attorneys are trained to issue spot. Now, they do that for a reason, because the more issues they can spot, the more ways they can bill you for all of those issues that they have to run down. It's extremely frustrating as an individual when I see that, because I do have a few attorney friends that I actually like. Most of the attorneys I've dealt with I cannot stand, because I think they're underhanded. I think they're liars. They hide behind their clients. They tell, well, I didn't say this, my client told me this. And they make stuff up. And as a result, it just prolongs the litigation. You know, because the truth is never allowed into the courtroom. I remember my grandfather, he was an attorney for 50 years. He told me this joke. He said, Clint, there's a witness on the witness stand, and the judge finally had to look down at the witness and instructed him, said, sir, you must answer the attorney's question. Quit stalling. And the witness looked up at the judge. He says, Your Honor, I keep trying to answer the attorney's question truthfully, but this SOB over here keeps objecting every time I open my mouth. That's the impression people get when they're in the courtroom, that they want to tell the truth, but you can't get the truth out. So you do not want to be involved in a lawsuit from many different standpoints. Most of it is because your life will be turned upside down. You ever been deposed before? Has anybody been deposed? What do you think? It is. Sir, you were deposed? Business environment? And what did you think of the deposition? Greg, Mike? The attorney told you to keep quiet. Yeah, well, that's good advice. You always tell your clients not to say anything, because oftentimes they say too much, and that's what gets them in trouble. For example, here's how I might depose you. What's your name? Bob. Okay, Bob, what do you do for a living? Bob tells us he's retired. Well, that's good. You married? Okay, Bob's married. Are you still cheating on your wife? Now, see, Bob doesn't want to answer that question. Bob, that's fine. We're not going to, I don't need to know the answer to that question. That's too personal for you. We wouldn't want your wife to find that out. So I'm going to move on to the next question, Bob. Are you still cheating on your taxes? Again, Bob's not going to answer that one, I can tell, because he's concerned that the IRS may find out. Now, can I ask those questions in a deposition? Absolutely. Yeah, I can do that. Now, you probably say, that's not right. Well, nothing about the legal system is right. Yeah, that's how attorneys make money. And in fact, I've asked similar questions before on a much more personal level. My mother-in-law, when I've had to represent her in some situations, and I deposed her brother-in-law, we walked into the deposition, and he thought we were friends going in. And, yeah, well, I know. Well, yeah, he did, but he didn't understand what type of attorney I am. Okay? And the type of attorney that doesn't like people who lie, cheat, and steal. He's been working the system forever. Never really liked the guy. And now I'm going to depose him. He thought we'd go out to lunch. He said, oh, it's only going to take about 2 hours. This is a guy that was always go to work for somebody, and then magically, after he was eligible for unemployment or disability, he became disabled every single time. And then he would live out on those benefits and then go get a job once the benefits ran out. So we walked in there, and at one point during the deposition, his attorney had to restrain him because he tried to take a swing at me because of the questions. Another time he's sitting there blubbering like a little baby in the room because of the questions I was asking him. Now, I did my job because he was lying. See, my mother-in-law had built her house 5 feet over on the neighbor's property line, and the neighbor was asking her to remove it. It was her garage. She didn't see a problem with it because she said they weren't using the property. And what she was really upset about was that her brother, her twin brother, who lives right next door, he went and told the neighbor that the garage was over on their property because he was mad at his sister, and he helped build the garage, so he knew that it wasn't surveyed. Yeah, my wife comes from a screwed-up family, and she tells me that my family's messed up. So you can see here that, I wanted to take this individual and kind of dismantle him during this process to really ferret out, what actual knowledge he had at the time he built the garage, so that he did not come with clean hands. And that's what can take place in a deposition. You're being sued. It's a very uncomfortable process to go through, and it's something I would encourage you to avoid. So you have to understand what the threats are and how to avoid them. Here's a couple sources of threats. You're going to buy real estate afterwards. Do not buy rental real estate in your own name. Here's the thing. If you're going to buy property to hold long term, purchase the property in a limited liability company. You're going to have cash. So you're going to buy that property in a limited liability company that you will fund. It will not be the same LLC that you've set up to hold your dinar, because real estate is a dangerous asset, so we would never mix them. You set up a new LLC for this real estate. Now, I would suggest that you create one LLC per property. That is how I do it. I have one LLC per property because I'm an attorney. It doesn't cost me anything other than my time to set these companies up. In fact, down here, I have multiple LLCs that are just on the shelf in my office down here that are just waiting for we're looking at a property right now. When we go to close on that property, we will take title in the LLC that we have already created to hold this particular property. Now, your LLCs must be created in the state where the real estate is located. That's important as well. You would not set up a Nevada LLC to own property down in Florida. You would create a Florida limited liability company for that property because that's where you're doing business. But the reason why that's so important is that if you own rental real estate, you're going to be renting to somebody. And the law is going to hold you to a higher degree of culpability if something happens to that individual because they're looked at on a different plane than you. Because as a landlord, we look at you and we say, well, you're a sophisticated individual. And these tenants, we have to protect them because you're taking advantage of them by giving them a house that they can live in at a reduced rate. So that's taking advantage of them. Well, tenants can sue you for anything. And we've noticed there's been an uptick. When the economy goes down, our clients are experiencing more problems with their tenants, with threats of lawsuits, where they're shaking them down. And the thing is that if you own everything in your own name, all of that is at risk. So you want to get your assets out of your name and you want to put the real estate into an LLC, so now you've shielded yourself. So you don't have a problem with the tenant bringing some bogus claim against you. This is the most important one, I think, when it comes to owning any real estate going forwards, is environmental. Right now, this country has taken the position that if you own property and there's anything on it that is discovered, you are responsible for the cleanup on that particular property. So if it's your property, you bought it, you did not perform an adequate study before you acquired the property because you thought, oh, this is a great deal, I'm going to run out and buy it. It's later determined that it has been contaminated from whatever, people dumping chemicals on the property. I know of an individual who purchased some property in San Francisco at one point in time several years ago, found that the building that he bought, at the bottom floor of that building, at one point in time, there was a dry cleaning business that was run out of there. Dry cleaning businesses used to dump all their chemicals right down into the drain or, maybe out in the back. In fact, there's a Superfund site in Tacoma from a dry cleaning business that was there for years that they're working on cleaning up. Well, they were doing construction 3 or 4 blocks away. They found the chemicals in the soil on a phase 2 environmental study, and they traced it all the way back to his building. And the EPA, the state, said, you have to clean this up. I said, no, I don't. Oh, yes, you do. We will lien your building. Fine. Take my building. I bought it in a limited liability company because the cleanup was more than the value of the building. So that's environmental concerns right now are extremely important to any individual who's going to acquire property. We were looking at a commercial property in Gig Harbor last year, and we decided to perform an environmental 2 study where they took core samples. They went 30 feet back onto the property that we were considering purchasing, and they found gasoline all the way up to the property line. Now, had we bought that property, and they wanted, I think, what was the purchase price? $800,000 for that property? $800,000 for a piece of property, which they've estimated that the cleanup costs were going to be $600,000. I'd be so upside down right now, I couldn't sell it had I not performed that study. One last point I'll leave you with, and this is why I hate attorneys for the most part in general. I have a client that I structured about 4 or 5 years ago. She came to me. She's right now about, I think, 85 or 87 years old. She's being sued for a situation that occurred over 30 years ago. She's being sued for over $2 million. Over 30 years ago, her husband bought a boatyard in Gig Harbor, and they repaired boats there right on the water. You'd bring them in, and they'd fix them and paint them. Now, at that time, all the chemicals that were used washed right down into the harbor. The owner of this property, since they had sold it, I think he's like the 6th or 7th person to own this boatyard, has been served with a bill for the cleanup that they found out in front of it. So he's gone through the chain of title, and he's sued everybody that owned that property for cleanup costs. And now he's down to this individual. And here's an 87-year-old person, a woman, a widowed person, who's being sued for over $2 million. I think it's $2.5 million to pay for something that her husband did, which at that time was legal 35 years ago or so. That's scary. That's how environmental claims work, and that's why I'm so emphatic about individuals acquiring real estate, especially commercial, in limited liability companies to protect yourself from that type of claim, because it can come back to bite you when you think you've moved on. So environmental is important. Personal injury. This is the outside stuff. This is where you do something wrong. Okay, you're involved in a car accident. You go out. I mean, I've talked to some people who told me they've already picked out their Ferraris, their BMWs for their kids, and I scratched my head. Why are you going to buy a 17-year-old a BMW M3? What do you think they're going to do with it? Okay, they're going to drive slow. You're going to put a governor on it so they can't go above 65 miles an hour? No, you buy an M3 because you want to go fast. And you don't know how to drive to begin with at that age. You're just going to create harm. So personal injury is one in which you're involved. You've created the harm. And it doesn't matter if you're right or wrong. When I was in law school, first year law school, there was a job posting. And it said, you want to make $300? Easy $300, writing some letters? I said, absolutely, that's what I want to do. And it said, law offices of William DiPolito and Associates was the attorney. So I grabbed this piece of paper and I go up to this law firm. I knew about the law firm because when I was in high school, and I'd come home late at night, I couldn't fall asleep right away, and I'd turn on the television at 1 o'clock in the morning. Law offices of William DiPolito and Associates. If you've been injured through no fault of your own, call us and we'll get you a just recovery. So I went up to this guy's law firm, and I walked in. I said, hey, I'm here to apply for the job. He brought me in his office. First question he asked me, you a creative writer? I said, a creative writer? I said, yeah, I'm taking creative writing right now because that's the first class you take in law school, one of the first courses. He goes, good, then you're qualified for this job. I said, perfect. What do I have to do? He goes, I want you to write a 10-page letter explaining why our client is entitled to receive the amount of money we're requesting. He would tell me how much money we're going to request from the defendant. And he said, I'll give you the case file, and you put together this 10-page letter. And each one that you put together, I'll pay you $300. I looked at him. I said, well, how many do you have? He said, you see this round file cabinet? Remember, this round thing spun around? We got plenty. As fast as you can write them. You could make $3,000 in the next week if you were so inclined. Now, here I am, first year law school. I went to law school to make money, right? I mean, that's why we become an attorney. I'll take as many as I can get. Now, what was an eye-opening experience is that when we figured out I was going to get engaged in this, I said, well, let me see the first file. So he went and he grabbed something, and I don't know, nothing up here really compares, like this piece of paper right here, something that looked this thick, just like this. And it was one sheet of paper really in a manila folder. So assume this is a manila folder. There's a piece of paper in here. And he goes, here's the file. And what I found inside of this manila folder was an accident report and some notes, some handwritten notes by the attorney on the initial intake when this client came in seeking his services for recovery of injuries that were, no fault of her own. And I looked at him and I said, what do you want me to do with this? He said, you need to put together a 10-page demand letter. I said, but I don't have many facts. He looked at me, said, you said you're creative. I said, all right. So do you want me to make stuff up? Is that what you're asking me? And he said, listen, if you use those words in my office, you're not going to have a job here. I said, okay, well then, if I'm not making it up, what am I doing? He said, you are putting yourself in their shoes. Visualize if you had sustained similar injuries, because there's a list of the injuries, thoracic this and that and that. How would your life be affected on a day-to-day basis? Put yourself in their shoes and put me together a demand letter seeking recovery for X sum of money. Give it to me, and I'll make sure that the client verifies this is how their life has been affected as a result of that. What did I do? I said, give me 10. I wanted to make $3,000 in a week. All right? I was going to be an attorney. I thought that was the way to go. I was good. There'd be nights when I would show my wife and go, honey, look at this one. She goes, wow, that is some good stuff. That's probably your best stuff to date. And this went on for a while, and finally I did quit. And people, why do you think I quit? Any ideas? Couldn't stand yourself anymore. Why? Because of conscience or something like that? Come on. I went to law school. Attorneys, that's the first question they ask. Do you have morals? If you say yes, you won't get admitted. Okay? So the thing is, when I came down to, I don't know how many I did put together, a lot. I had a database of these things. I ran out of ideas. You know, you can be so creative for so long, and finally it got to be really boring. And I realized, hey, this is the wrong way to make money at the practice of law. And so I quit working for them. Then I went to work for the prosecutors, and I realized they were just as messed up. I mean, the whole system screwed up from start to finish. I said, I need to go into asset protection, actually protect people from prosecutors, from all these other attorneys that are out there bringing frivolous claims, because they were just as bad. And so personal injury is something that, you know, you should be concerned about. It is a threat to you. Another, whoa, this guy, Dickie Scruggs, he's the problem. This is what we call the billionaire attorney, Dickie Scruggs. He wrote here, this was in the Wall Street Journal, it says, any lawyer fresh out of law school can walk in there and win the case, so it doesn't matter what the evidence or the law is. He gave this interview to the Wall Street Journal in 2003. This individual sued a lot of big companies, tobaccos, and he made billions of dollars suing them. And it didn't matter whether or not the defendant should be liable. All he was doing is shopping for the right jurisdiction to bring the case, find the right jury pool, and you were held liable. These companies were held liable. That's who he was going after, the deep pockets. Now, you put that on a personal level. This is what people do not understand about our legal system. It's supposed to be a jury of our peers. So let's assume that I'm in a situation where I am being sued by a tenant for not giving them or not providing certain or not having the house in a certain condition that they felt was appropriate. So they bring a claim against me, or let's say it's for mold. Now, who should be on that jury pool? Should it be tenants or should it be other landlords? You would think it should be other landlords who deal with that. You think it should be tenants. Well, I guarantee you every tenant that's going to sit on there has had a beef with a landlord at some point in time. And when you're up there, hey, this is the time to get back at them landlords. They get from the medical profession. If you're a doctor, shouldn't it be doctors sitting in judgment of you because they understand what you did? How is it a person who's never gone to college or even been in an operating room going to understand procedures that need to take place in operating rooms? So our system is really kind of messed up. I mean, my mother-in-law, she's a nice person, but she's the last person you want on a jury pool. She tries to get on. She'll go down and hang out the courtroom. Pick me. Well, sorry, Miss McCorkle, we didn't even call you for jury duty yet. Yeah, but I got the free time. She gets excited when she's on jury duty. She's been called probably 2 or 3 times this year. And I'm just shocked. But she sees it as an opportunity. It's like being on a game show for her. And a lot of people, well, it is. And a lot of people view it that way. So they will say things in order to get on the jury because they enjoy being in that drama. And that's a real problem with our legal system. The way maybe back in the day when it was created, it worked. But now we've become so specialized. And there's so many other laws out there. I think it's the wrong way to go. Fortunately enough for this scumbag, okay, he ended up in jail. So he's in jail right now with Bubba doing a 5-year stint. And he had to pay a $250,000 fine. You know what he's in jail for? For bribing a judge. Finally, I don't know how many judges he bribed beforehand. Finally, one of them turned him in. Because I firmly believe this was not his first time at trying to bribe a judge. I'm sure a lot of other judges have been bribed. He just bribed the wrong one this time. So he's in jail. He loses his law license. But when he gets out of jail, he still has billions of dollars. I mean, this is how the legal system treats their own. You're an attorney, you go out there, you do this nefarious act, I will slap you on the wrist, you do 5 years, come out, live a life of luxury. What about all the lives that have been destroyed as a result of that?
Collateral damage.
Yep, doesn't matter. All right, children, they're a source of threats to you. Anybody here still have children? Okay, a few of you. Now, how can children be a threat to you? Simple. They do things without appreciating the risk. When I was a kid growing up, I was an indentured servant. Okay? Literally, my brother and I were both indentured servants. The only reason we engaged in sports was because it got us out of having to work for my father on all his various properties. And so I got to know the apartment managers at my dad's buildings because I would go in there if I was in sports every weekend. Saturday for sure, if not on a Sunday as well, half a day on a Sunday, my brother and I would have to go in there and gut out apartments, paint, construction, the whole deal. So I got to know my dad's apartment managers. Now, when I was in high school, what are high schoolers going to do on a Friday night when they go out? Yeah, they're going to get beer. And I got beer. I had to drive 35 miles out to a place called Wildcat Lake, this little store that was out there, and it was a 35-mile speed limit, so it was an hour getting out to Wildcat Lake. You know where that's located? Yeah. So I drive out there to this little store, buy my beer, because out there they had nobody. So you walk in, I'm a bigger kid. You 21? Sure am. Okay, here you go. Don't get in a wreck. So I'd take the beer, put it in my car, and then I'd drive back at 30 miles an hour typically. Because you don't want to get pulled over, you have beer in your car, so I'm driving even slower. So there's an hour out and about an hour and 20 back. 2.5 hours are gone in my night just to get beer. And I realized this is crazy because the party's already been going on at that time. Or I have to leave too early. My mom would say, why are you leaving so early to go out? Well, Mom, I have to drive so far to get beer. What do you expect? So what I learned is that rather than go out there, I'm going to go to my dad's apartment buildings. And so I went down to my dad's apartment manager, and I said to him, will you buy me some beer? He said, absolutely, Clint. I will buy it, provided you do not tell your father. And I said, well, of course I'm not going to tell my father. He goes, one other requirement. What's that? And he goes, you have to buy me beer as well. I said, excuse me? He goes, yeah, for every case I buy you, you have to buy me a case. So he was shaking me down. But it was okay. Because you know what I did? I brought my friends with me. I said, hey, guys, this is my connection. You guys have to pay. Otherwise, you'd be driving 2.5 hours. So they would pay for the beer. Now, where's this all leading to? Well, the fact is that I created liability for my dad at that point in time. He owns a lot of real estate at that point in time, but he was not protected. His father was an attorney, and my grandfather never sat down with my father and said, you need to do this for these certain reasons. So my dad just dealt with the lawsuits as they came his way. Now, I made a mistake. Luckily, nothing happened, but not only did I create the liability, when I introduced these friends to my dad's apartment managers, they started going and buying beer when I wasn't going out with them. That's where they would head. And I found out later that oh, yeah, Clint, thanks for that connection. That's where we go now on a Friday night or a Saturday night when we cannot get beer. We'll go right to your dad's apartment manager. He's been great, but he's starting to, want too much from us. Can you say something to him? Like, oh, that's not what unanticipated consequences as a result of your actions. And so as a child, I didn't appreciate the risk, but now as an adult, I definitely do. And so children are a concern. I mean, they create harm for us because you are liable for their actions. Service as a corporate officer. You run a company. You can be held liable for what other people do in your company. You want to make sure that you have a shell around your assets, that people think that if I set up a corporation, I can operate with impunity and I can't be held liable. Mistake. You're liable for your own acts, for whatever you do. So there's liability there. So you want to make sure that you're protected, because when you run a business, things will happen. How many people here want to buy, people often talk about, I want to buy a corporate car. I want to own a car in my corporation because I'm going to write it off. Now, I'll give you an example of that. My father, this year, he's going to buy a new Ford truck, an F-350. We're going to write it off under Section 179, depreciate the entire vehicle up front because it's used for his real estate investing. He owns a lot of real estate, so he's going to use it to drive around. Makes sense. Now, at one point in time, I owned a vehicle through a corporation, and my wife used to drive it around. Okay, simple enough, not a problem, until one day I get a call. She says, honey, I was in an accident. I ran into the back of somebody as I was pulling into so-and-so parking lot. Much damage. You tell everybody you're concerned about your family? Okay, honey, do you not understand that if you were calling me, that means you're okay. If I was getting a call from a medical tech or somebody else, then I would know you were hurt. But obviously you're fine because you can call me. Don't try any of that logic on me. So I dealt with that for a good 3 or 4 weeks after that accident. So I said, I'm sorry, are you fine? Like you would care. I said, I do. But what were you doing? And then she turns the tables on him. She goes, why do you want to know? I said, well, were you driving the car for business or were you driving it for personal? She's got real quiet and said, well, because if you were taking it for business to go make a deposit into the bank, when the officer shows up and if you said that, that might imply that you were on business when the accident occurred and the business is going to be liable. But if you were going to the grocery store, which is right there as well, to purchase groceries, then it was personal. And so the business wouldn't be liable. Which is it? She goes, I'm not going to tell you. And she hung up. So it took me a while to get that response out of her. But you see what I'm going with there is that if it's if it's with your you're working for a company, you can bring your company liable, and if you're the officer, you'll be liable as well. So you want to make sure you're protected. It's not working. So joint tenancy, general partnership. This is another area of liability. Never go into business with somebody unless you have some structure around you. I've talked to quite a few people who have told me that after this RVs, they have plans for their currency, that they're going to go and create a business. They plan to go into business with somebody else, some friends of theirs who are also invested. Let me tell you, you better get yourself in an LLC or in a corporation for that business, because if you go into business with another person, you're all liable for the harm. That's the way it works. It's called joint and several liability. So if we created a business here, I'm horrible with names. What's your name, sir? We have Robert. Mike, can I get the mic up here, Greg? We have Robert. What's your name? Pat. And I know Ron, that's right. Robert, Pat, and Ron. You just put it right there so they can hear. Okay? So Robert is worth $2 million. Pat, well, forget about the exchange. Let's just say that you're worth $500,000, and then Ron is worth, no, you're worth nothing. Okay? Your wife has it all. You're worth nothing. That's the truth. So Ron's worth nothing. Robert has all the money. Pat, you have all the ideas. And Ron, you have the ability to sell. Okay? That's how businesses come together. People get involved. Money man, logistical man, salesman. Now, you decide that you are going to sell ice cream cones outside of Disneyland. Pretty good idea. Why would somebody want to buy an ice cream cone before they go into Disneyland? Because when they come up to Disneyland, they know as soon as they walk through the gates, that ice cream cone is going to cost them $15. So why not stuff the ice cream in the kids now before they go in, so they have to spend $15 when they get it for $3 right outside the gate? So you put together, you negotiate, Pat negotiates with the city to have the spot right outside of the gates for their ice cream stand, puts a cart, gets 3 flavors of ice cream, gives it to Ron. He starts selling ice cream. They're doing great business. Silly business. Now, they're making all this money, but all of a sudden what happens is somebody from another competitor ice cream company comes into town and sees Ron throwing the ice creams as fast as he can to all these kids. It's your business, Ron. It goes down. People quit going to you because they can go across the street for all the fancy flavors for the same price. So his business shoots up. Now, you're hurting. Robert contributed $100,000 to the venture. He's looking for a return. You're not getting any more. Pat doesn't know, he's just sitting around going, well, there's nothing I can do. We don't have any more money. You don't want to put forth any more money into the venture. So what happens is, Ron, you decide you're going to figure out how to make money at this deal with the limited resources you have. Since you don't have anything, you look around and come up with a new flavor. You find, hey, rock candy ice cream, and what he does, rather than go out and buy it, you find the rocks to mix into it. So he mixes little tiny pebbles into all the ice cream and figuring, hey, the kid's going to bite into it, think it's a jawbreaker, they're just going to swallow it, and they won't know. I mean, come on. When you get something hard in your mouth, sometimes you're like, either spit it out or swallow it. You only got 2 things you're going to do with it. You're not going to try to bust a tooth on it. Most times kids will just swallow. So you make that assumption, which is a fair assumption, and then you decide that's not enough. We need more. So what he does is he obtains some Mylar balloons shaped as Mickey Mouse, because, again, here's the idea. Why buy a Mickey Mouse balloon for $7 inside when you can get one for free with an ice cream cone outside to inflate them? What he's pouring out of their mouths and it's running down the shirts, and the moms are screaming, the balloons are sitting right there, and you have other people sitting around smoking, and they're exploding balloons and dropping hot Mylar, and everybody else that's walking in. Who gets sued? Do you get sued? Absolutely. How about you? Well, yeah, we already just established that. You just look guilty. Okay? Why are you going to get sued? Because you have deep pockets, but you didn't know what he was doing. It doesn't matter. See, that's the whole point. It doesn't matter. When you go into business with somebody else, joint several liability, they're all liable. The mistake that most people make in life is that they assume that the business structure should come after the business starts. And that's the wrong assumption to make, because each person can bring liability to the other parties in that particular business venture. You're essentially married to them. And if they get a divorce, you're going to go through that divorce. And many times that'll destroy your business. So joint tenancy general partnership is not how you should conduct any businesses afterwards. The other thing we have here, there's just too many attorneys in the world. There are more attorneys in the state of California than any other industrialized country. That's a statistic. It's pretty darn scary. How do the attorneys make their money? From suing people. I mean, that's the only way they're going to make money, is by creating liability, you know, going out there and drumming up cases. I'll give you some examples of that. Look at this. This is a website you can go to. It's called whocanisue.com. So if you don't know if you have a lawsuit, go to this website. You might find you actually can sue somebody. And if you can't find somebody, go to this other one called Sue Easy. They guarantee they'll find you somebody to sue, or a reason to go after somebody. Now you laugh, but this is stuff that is allowed by the Bar Association. The legal community does not shut this stuff down. They permit it. And these attorneys create havoc in our society. Recently, the Taco Bell was sued, were they not? A class action suit was begun against Taco Bell a month and a half ago or 2 months ago, because the meat content in their tacos, they alleged, was only 79%. And they state that their meat content is 80 or 82 in their advertising. So attorneys got together and sued Taco Bell over 3% meat discrepancy. Now, that was a shakedown. And it was dismissed because it was found there was no basis for it. And even though there might have been a 3% discrepancy, so minuscule, who's hurt by that? Okay, so I get more beans than I do meat. Am I buying a taco because it has 82% meat content? No, that's not why I'm buying it, because it tastes good and it's quick and it's fast and I want to get out of there. So Texas, they threw it out. Now Texas, what they've done now, which is nice, is they've instituted a new law that if you sue somebody and you bring a frivolous case and you lose, you have to pay the other side's attorney's fees. That's great. That's how you get rid of all the legal problems in this society with all these attorneys. You say attorney. You make the attorneys pay, not their client. You make attorneys jointly and severally liable with their client, because really when an attorney brings a case where they get a piece out of what they collect, they're in it just as a client is. So you hold them personally responsible. Then you clean up all these issues. But Texas is the first one to do it. Hopefully more of them will. Is third-party information admissible in court? I don't necessarily know what you're referring to.
In other words, can he speak for me? Can he say, this is the truth?
He can only say what he believes is the truth.
So third-party information, right?
Well, he can say, well, as long as you're there and you can testify to rebut it, his information can be admitted. Absolutely. That's what witnesses are for. You bring in a witness to, tell their side of the story. Well, what is it that you heard? Okay, blah, 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 blah. Now, you can go up and you can say your side of the story.
Right, but what I'm saying is...
Can he speak on your behalf?
Yeah.
I don't know. I don't think so. Yeah. Well, you want him to be, what? He looks more, well, he obviously looks more trustworthy than you. So there you go, right? Yeah.
I just wondered, because it always never made sense to me, because isn't an attorney third-party information? I mean, really,
Attorneys do not testify.
Right, but he's translating what you say.
Okay, the question is, can somebody else speak for me in court? No, they cannot. Only you can testify for yourself. They can be called as a witness for their own personal knowledge. If they do not.
Back to your last point about the general partnership, if you hire an attorney to represent you for a case, you should go into a general partnership with them for that case. That way it makes them liable.
Well, yeah, but attorneys, they have statutory immunity from that, I assume. So it's never going to happen. Sued for what happened yesterday. That's my client in Gig Harbor that's being sued for something that happened 33 years ago. Liability, never know when it's coming. Too many laws. This is the last one I want to show you here. There's just way too many laws out there in this society. You don't know them all. The Federal Register now is 15,000 pages. Those are 15,000 pages of federal laws that we have, and they add to it every year. Make the problem go away. I'm sure next year there's going to be a law against flooding, and down in the South, and we're going to handle that with some new laws. I mean, it's absurd. Where our country has gone with laws, and as a result of that, you get trapped in this because you cannot know all of the laws that are out there. My father, here he is in real estate investing when I was a kid. You think he would know some of the, they're not going to leave behind their 50-inch plasma television. They're taking that with them. They're going to leave behind the box that the 50-inch plasma came in. So tenant came back. This is what precipitated all this. Came back in election. I mean, all this these other items. And my dad was sued, and he had to pay a couple $1,000s because it was junk. We couldn't prove otherwise. So, yeah, Greg, I'll break in a couple minutes here. So what happened was after that, what my dad did, he told my brother and I, he goes, listen, I'm going to find out where they live, because he didn't want to keep this stuff, because you have to hold it for a set period of time before you can throw it away. So he'd find out where the tenant moved to, and then we would box it up, and then we would go to their house where they're living now. You go up to the door, you knock on the door, you see the curtains move, but nobody comes to the door. Oh, that's strange. Must be a ghost in that house. So we tell them, we're here to deliver the items that you left when you abandoned the apartment that my dad owns, just letting you know. So we'd start we're emptying the boxes out of the back of the truck. All of a sudden, a policeman shows up in the driveway, threatens to arrest us for illegal dumping. Yeah, then the tenant came out. I don't know these people. They're his previous address. They listen, you cannot dump this. It states, urinals and toilets are served with gray water. Do not drink. Okay, why do we have that warning on the wall? That you have to go to that? Extent now in order to protect yourself with these types of warnings. Here's another one. This is at McDonald's in California now. All McDonald's in California, this is because of a law that California passed regarding you have to disclose any type of chemicals in your food that could lead to possible cancers or any other type of deadly disease. Otherwise, you can be sued for it. So McDonald's put this sign up now in their McDonald's. It states chemicals known to cause cancer, birth defects, or other blah, 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 contain certain foods, are in certain foods or beverages sold or served here. Cooked potatoes that have been browned, such as fries, blah, 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 French fries, all this other stuff, have a chemical known to the state of California to cause cancer. Okay, these chemicals are naturally occurring whenever you cook food. So they're not added by McDonald's. It just happens when you brown food. So we have to warn people, if you want to eat our cooked food, then you have to know that there's a potential that you could have birth defects. I mean, this is how stupid it is. You know what I really think that they have this law for now? Why they put this sign up? Remember the coffee cup case? Yeah, I guarantee you what they probably do have to give you that hot cup of coffee now because they got sued over that. They say, listen, before you drink, read the sign. By the time you're done reading this sign, that thing's probably cooled down by 10 to 15 degrees, and you can drink it all day long and you won't get burned. All right, moving on. This is the best one. Okay, this is a sensible warning on a floor sander. This is the way society used to be. You're aware of. We'll talk about why it happens. We're going to take here a short, probably 5 to 10-minute break. We'll figure about, what do you think, Greg? 5 minutes, 10 minutes? 10-minute break, and we'll start back up again. Coffee. Where's the coffee? I'll get it. In the lot, there's coffee. There's a blue coffee cup.
Testing 1, 2.
Okay.
I'm going to take, in every major city, I'm going to take out full page saying, thank you, President Bush, Vice President, for setting up the plan.
All right. We're good? Mike, back up. All right. So, yeah, I mean, we talk about conspiracy theories on that break. I think possibly the government is doing something to my computer system today to prevent this information from getting out. Yeah. Yeah, first my office is attacked and we lose all our server down there this morning, and then Omnovia, one of their servers went down today, and then now we have this issue with the laptop. So, all right, so moving on. Why does this happen is the question. Right. Which, by the way, I'm going to be putting all this on. Yeah, there we go. That's what I look like when I'm relaxing at home right here. Procrastination, of course, that's when it comes to planning. Why most people fail to plan is because they think it, I can deal with it later. I don't need to deal with it today. And I've seen that a lot when I ask people, well, why didn't you do something different? Well, good question, Clint. At the time, I just thought I had some more time to consider the options. And so we tell people you don't want to wait. I mean, especially when it comes to the RV, you want to have things ready to go and understand what your options are so that you're able to go in and make that move to wherever you want to put your currency. If you don't want it in your own name, your LLC should be set up ahead of time. Because at that point in time, it's going to take some time to get things established. And so people have to realize that. It's not an overnight thing. You just can't set up a company and have it up in 24 hours and expect to have a bank account. It just won't happen. So when do you need protection? Before you've made it or after you made it? Okay? Everybody says before in this room. Why is that? Because you've heard me say this before? What's that? Okay, so to paraphrase, what was said is that you stepped up and you saw that there was an issue there and you wanted to take action. A lot of times when people will go into an attorney's office, they'll be told, wait. You do not need protection until you have more to protect. So essentially what they're telling you is that until you're worth several $1 million, the money that you do have isn't that important to the attorney. And it shouldn't be that important to you because you don't have enough in their mind. And I hear this from CPAs as well. And so my pat answer whenever I'm dealing with a CPA or an attorney of that mindset is take the example of two individuals, one that's worth $10 million, one that's worth $100,000. Both of these individuals are sued for the same reason, and a judgment is entered against them for $1 million. Who is better off, $10 million guy or $100,000 guy? $10 million guy. Okay, you say $10 million guy. The reason being? He's got a trust. Because he has the money, to pay it. So if I sued you, forget about asset protection, and you had $10 million, and I take $1 million away from you, you have $9 million left to play with. If you have $100,000 and I sue you for $1 million, and I take $100,000 away from you, did you just lose $100,000? Yes. But you also have a $900,000 judgment that will grow at 12% annual rate of interest that will follow you around for the rest of your life. So when we look at people and ask them who needs protection more, yes, rich people do need protection, having all that money, but at the same time, you can oftentimes afford a multi-million-dollar lawsuit, whereas the guy who doesn't have the money cannot afford it, and it will destroy them. And then going back to the doctor that killed or accidentally killed his brother-in-law. He's being sued for several million. His insurance does not cover him. He said, well, what happens if they take all my assets? I said, well, then the judgment will follow you around unless you can bankrupt it away and get away from it. But there's not much you can do there in that point in time. So it is before you made it there where it becomes important. Now, what stops people from moving a lot of times is fear. And I define fear as false evidence appearing real. It's not understanding where we're at, so it's a fear of taking action. And many times when you deal with individuals who have not been exposed to this type of information before, they will freeze, hesitate, and not do anything that they should be doing because it's unfamiliar territory for them. That's why we put such a strong emphasis on education, is to understand what your options are and why they're there. Not that you have to become an attorney, but just understand that there are different options available to you, and before you take action, you seek out advice. All right, so some of the asset protections myths: only wealthy need protection. That's a myth. Not likely to be sued. I think that's a myth as well. Average individual will be involved in 5 lawsuits during their lifetime. My mother-in-law has already hit her 5. Talk about insurance agreements. Yeah, I've had to defend her all 5 times. She owes our firm, with interest, probably $65,000 to $80,000. Try telling your wife you want to collect on that. She looked at me and she said, "Am I not worth that much money?" And then she thought better of it and looked at me and said, "If you do send her a bill, because I don't want to know your answer to that, there should only be one answer, you better sleep with one eye open, Clint, for the rest of your life, as long as you're married to me." So my mother-in-law's got away with 5 lawsuits that she's got for free. And much of that comes from not seeking my advice before she does something. She just thinks that she can act. For example, the garage that she built on the neighbor's property line, I was out there when she started building it. And I asked her, I said, "Nancy, how do you know that's your property?" She said, "Well, that's my property line right there." "Okay, did you have it surveyed?" "No." I said, "Well, how do you know?" "Well, it's obvious. Their property's here, and that's where they built, and so I'm going to build up to here because there's nobody's built there." Okay, that doesn't make it your property, but that was the way she operated because, you know, she just figured she could do it. If something came up, I would be there to protect her. Insurance will protect you. This is another myth as we started talking about. Look at this guy. Will insurance leave you exposed? Won't cover multi-million-dollar claims. Environmental claims is something it won't pick up. Rental real estate, one of the problems you have with that, for those of you who want to buy rental real estate, is mold. We've had a few clients who have been sued over mold. Their insurance company will not cover that claim. You're fully responsible. You look in your insurance policy, you read the back of it. Many people haven't read their insurance policies because it really doesn't matter. You have no bargaining power. You look at the back of it, you'll find that those certain exclusions, environmental contamination is always one of the major exclusions they have in your policy. Mold is one of the areas now in which attorneys are finding ways to line their pockets because asbestos cases really don't pay out like they used to. And so now they're found toxic mold as the way to go. In fact, we went to CLE and the attorney walked in, he was so crass, he wrote "mold equals gold" up on the overhead. And half the room started doing this, clapping, because they were looking for the information on how to go out there and bring these types of cases and what's sick. And this is why I don't like attorneys. He put up on the board a list of experts that would represent, that you could call. It would always say there's mold in the property. And he looked at the room and he says, "I realize there's some people in here who defend people in these cases. I don't want to feel that you came to the seminar and you didn't obtain any information as well. Call this list of 6 experts. They'll always testify that there's no mold in the property." So what does that tell you? Okay. And then we have a jury pool who doesn't understand anything. They're just happy to be there because it's a free meal and some bus fare, and they got nothing else going on in their lives. And so who can you convince? So that is a problem. Business failures, bankruptcies, IRS audits, contractual disputes. I mean, as you get the hint here, you know, you can judgment-proof yourself. Insurance is not there to cover you. So how do we go about protecting yourself? First step, I've talked about this on many occasions, and that is to use a limited liability company. That's what you need to set up, is an LLC. It should be there to protect you. Now, what are some of the benefits of the LLC? Number one, we talked about this. It hides wealth from prying eyes. Now, how does that work? Let me show you how it works down here in Nevada if you set up a Nevada limited liability company. So when we establish a limited liability company, an LLC, let's assume we set one up in Colorado. And we have Fred here. Okay, he is the individual who wants to set up this LLC. Well, when I file for the LLC in Colorado, I must list Fred as either the member or the manager on that limited liability company. So that tells anybody who is able to get on the internet and look up Fred's name, they'll tell them, hey, Fred has a limited liability company now. And let's assume Fred establishes another 3 or 4 limited liability companies. Now, does Fred start to look as if he's got a lot going on in his life when he has a lot of businesses that are tied to him? Absolutely. So then the question becomes, well, is Fred a target? Well, he has asset protection, but it doesn't necessarily mean that he won't be sued, because a lot of times cases are brought on the assumption that if I shake the tree hard enough, fruit will fall. And if I'm able to bring a case against you and I make it emotional enough for you, you may start dropping fruit, because rather than fight the case, you're willing to pay to make it go away. And we find that a lot with individuals who have strong cases. They will pay something over to the plaintiff, and the attorney knows that. They'll tell you, listen, we'll keep this going on for 3 or 4 years, or you pay us this money now, and we'll stop it. I think they want you to click the pencil. All right. So this is an issue. So how do we protect it from prying eyes? Well, one of the things that we've recommended is that you create a Nevada limited liability company. And the reason we set you up in Nevada over your state in which you live is that there are unique laws here that allow us to hide your ownership. And we do that through what is called a nominee. So one of the individuals in this building here, the attorney who's a partner in Anderson, he also is the one of the principals who runs and operates BOSS, their CEO. He will serve as your initial manager. So here's the attorney. This is Toby. For those of you who've seen him, he's got a little goatee. He's there as your initial manager for your limited liability company. Now you're back here, standing behind him, maybe you and your spouse. You're what we call successor manager. So what happens when we file this entity, we have to list the manager of your limited liability company with the Secretary of State. So when we do the initial filing, we list Toby. And so he signs off on the LLC. So he's appointed there. Now, after the LLC is set up, it's been filed, and then we draft your operating agreement, Toby resigns at that point in time. So he disappears. He's no longer part of the limited liability company. He's resigned, and we've appointed you individually, as the successor manager of your limited liability company. So you're behind this curtain here. So if anybody performs an asset search, runs your name through a public search engine that searches all 50 states, including the databases for where you're going to pop up and what entity business you're associated with, your name will not be associated with this limited liability company, because what they will see is Toby. Even though he's resigned, that resignation does not get filed with the state. The state in Nevada does not require that you update them every time there's a change in the manager throughout the year. So what we are allowed to do in Nevada and others in Wyoming, we can file the entity, appoint somebody as the initial manager, have them resign. Our clients then step into the controlling position, and we do not need to update the state that Toby has resigned. Nevada has set their laws up intentionally to encourage this type of entity formation, because they believe, as the state in general, that privacy is important. Now, I think that stems from, who really runs Nevada? It's the boys. And the boys don't like the IRS in charge, looking at what they're doing, okay? So this old boys club that, really started in Nevada, I mean, they've always sought privacy. So I think there's might be some of that to it as well. But it has become a cottage industry for the state of Nevada. They generate fees from people setting up their businesses here. So that's why they go about it this way. So it'll hide wealth. So Toby's there. You're in control. He has no control over your limited liability company. When we establish the LLC, we will then give people an option of Bank of America, Wells Fargo. We can no longer work with Chase. Chase has put a hold on the account operations right now, opening up new accounts from Nevada in this manner, and because they're revamping their account system, they told us. So we cannot open up a Chase account at this point in time. So we're down to Bank of America and Wells Fargo. Ordinarily, what will happen is that when we contact them, we will tell them we have a client. We're a law firm. We have a client that lives in Florida. We set up a Nevada LLC for them. They need a bank account created. The bank will then contact you, and then you will be in contact with them to finalize the account procedures. That will take between 8 to 10 days to get that account set up. So a question that I get a lot, and this was something that I dealt with, I was talking to Dan and Tony the other day on this particular issue, is if somebody's considering waiting to set up their LLC until after the RV, they're going to go out to San Francisco. Tony kept asking me, Clint, what is the time frame for you to set up a limited liability company for them? And I told them, well, it's going to take at least 3 to 4 days to finalize the LLC, to get it in their hands, minimum. But the bank account is going to take longer. Tony's concern was that if the larger denominations are only accepted, say for 30 days, does that give somebody enough time to set up their LLC, get their money, and then get those larger denominations converted and the money flown into their LLC? I told him, I said, well, if you plan to have this event 2 or 3 weeks after the RV, the answer to that is definitely not. It will not happen because the banking relationship is what takes the time. Now, you could come to Nevada yourself and open up the bank account. Once you have your LLC, you could walk in. But if you want to use the nominee the way we're doing it and you live out of state, you can't. You have to go through this process the way I just described, where we submit it to them. Otherwise, you have to come here and physically walk into the branch. So that's how the banking relationship works. Once the account is open, it's always in your name. Toby is not on that account. He has no control over the entity. He has resigned. It is strictly you. People often ask me, well, who is Toby Mathis? Should I be concerned with him? And I often tell them, it's not Toby that you need to be worried about. Toby's more afraid of you than you are of him, because he is the individual who is on that entity. And there have been situations in our past where people have set up entities and they've gotten into some trouble. And when the person is looking to sue the business because of some harm that took place, Toby will be served because they assume that he is the owner of that company because his name appears on it. And they cannot discover or discern who is actually involved because of the nominee protections. At that point in time, the typical response to any person in that situation that is seeking information is go get a court order. Absent a court order, we cannot disclose any information about our client. So it maintains that veil unless a court forces us to turn that over. Question?
As long as you have an existing Chase business account for your LLC, that's not a problem. It's only to get a new one.
As long as you have an existing Chase account for your LLC, that's fine. But for us to set up a new one in the manner in which we've been setting them up, we can no longer do that as of last week or the week before, because Chase told us that they are revamping their account opening procedure for out-of-state accounts, and that there's a moratorium or a hold on it until that's completed. Then they'll notify us.
I can give you and the rest of our people some good information. If you already have a Wells Fargo account and you set up your LLC and you select Wells Fargo as an entity, it can be done in one day on the phone and via emails.
Yes, that's a very good point. I bank with Wells Fargo, and when I log into my account, there are multiple accounts available for me that I can look at. All my limited liability companies, all my business entities have a Wells Fargo account, and there's also a personal account for Clint. The reason why I'm stuck with Wells Fargo is because when I need to move money, I can move money from this account to this account or from this account to Clint, back and forth, just by logging into the internet and moving the money around. Now, they do offer you the ability to open up an account once you've established with them over the phone. I've even walked into my local branch and opened up an account for my Nevada entity, and they've tagged it as a Nevada entity. But a lot of times what will occur, and you have to appreciate this, is that your process, that is when you're opening up an account, is oftentimes not determined upon bank procedure. It's determined upon the bank employee with whom you are dealing. If they do not understand it, then the safest answer they can give you is always no, because they're concerned about liability that they could bring the bank. So if you called the bank up and said to somebody, hey, I want to open an account up for you for my Nevada entity, and they hear the word Nevada, you're in Washington, they've never done it before, they're going to tell you, you can't do it, because they don't know how to do it. So rather than plead ignorance and try to get you the assistance, they're just going to say no. And so you have to understand, maybe push it up, maybe call some other banks. And the way you should always phrase a question is take it out of the yes or no category. Is, do you have anybody in your bank, in your branch, that is experienced with opening up accounts for out-of-state entities? Can you direct me to somebody else? And they might say, hey, I'm experienced with that. But try whatever you're dealing with banks, do not put them in a position where it can be a yes or no answer, because a lot of times the safest answer is always no, and that's what you'll receive.
Yes, I have a question about the filing requirements in the state of Nevada for the corporations. After the nominee resigns, does those paperwork have to be refiled every year to determine who is the managing partner of the LLC?
The question, okay, about the paperwork, well, after the manager resigns on an annual basis, then what occurs is this. So Toby disappears. Then next year when it's up for renewal, you appoint Toby again for the limited purpose of filing the annual renewal statement. So he's appointed for that limited purpose, and then he's removed again. Now, while he's there, does he have any control over your entity? None whatsoever, because he's only there for filing purposes only. So he couldn't walk into the bank and say, listen, I'm in here for filing purposes only. I want to gain access to the accounts. The banks would not permit that. Okay, so that's the way the system works. All right, so when we say hide wealth from prying eyes, that's what we're referring to when we create an LLC in one of these jurisdictions, is that we're able to remove it from your name. And so you're no longer associated with that entity. So that's why you've probably seen this one before. You don't want to look like that guy. You want to look like that guy when it comes to wealth. Yes.
We have a connection here at Wells Fargo too, for setting up accounts for trusts or any of that kind of stuff. Her name is April Vargas.
Yeah, April's great. Down here in Wells Fargo, the question is, April Vargas is a connection down here. Yes, I've known about April for setting up accounts at Wells Fargo. April Vargas. The account, does that work for Bank of America? Bank of America is notoriously difficult to deal with out-of-state accounts. If you have a Bank of America account presently, I'd switch to Wells Fargo. I'll tell you why I believe that. I had both. And 3 years ago, I had a contractor come out for some landscaping I was doing, and I had to write him a check for $15,000. So I went to my Wells Fargo account, pulled $15,000 out, put it in my Bank of America account. Bank of America put a hold on that check for 15 days, and it bounced. And my contractor was none too happy with me. So I called up my Bank of America, who I had been with for 10 solid years. And my average daily bounce, I don't keep a high one. Maybe it fluctuates from $4,000 to $7,000. But I never overdraw a check, nothing. All the checks I've always deposited from that other account have always gone through, not an issue. They just decided to hold that check because of its denomination. And it caused this check that my contractor really needed to bounce. And he was really upset with me. And I'd gone out of town, so that compounded it because he needed that money, and I couldn't get him the money until I came back into town. I had to write him a new check drawn on my Wells Fargo account so he could go down and cash it right away. From that point on, I said, I'm no longer dealing with Bank of America. And I closed my personal account, and I kept everything with Wells Fargo. Maybe it was an aberration, I don't know, but it was enough that it bothered me. The other problem that people run into is when they're dealing with tellers, they are oftentimes told that they cannot make a deposit into their local Bank of America branch for their Nevada LLC. Again, it's with whom they're dealing. The person they're dealing with is not educated on out-of-state deposits. You need to have a special deposit form that has all 50 states listed on it, and you circle Nevada. This deposit form is then coded for them so they know it's associated with a Nevada account. For some reason, the way Bank of America's system is set up, they're all disjointed.
They are.
Yeah.
Between Washington and Nevada, it's a night and house from Bank of America account.
So you have them, you understand what I'm talking about, that it's disjointed. Whereas Wells Fargo, it's so seamless. That's why I like them. I don't own any stock in Wells Fargo, so I'll make that claim as well. So I've just found them to be easier to work with. But I'll tell you this, if you decide to obtain any loans, if you're going to purchase any property, commercial real estate or investment real estate after the RV and you do not want to pay cash for it, do not obtain the loan with your bank. If you're dealing with Wells Fargo, seek out another bank for that loan. Because when you obtain a loan with Wells Fargo, say for a commercial piece of real estate, you pledge all of your accounts as collateral for that loan. You also will give them the ability to liquidate your accounts if they feel that their collateral is in jeopardy. They will do so based upon where your name shows up. That is, if you show up as a signer on the account, they will take that as an indication you are an owner on that account, and they will pull the funds, and then you will have to fight them to get your money back. I recently dealt with this, well, one of my clients has dealt with this situation with a bank in Montana. They took $2 million of his dollars out of his personal account as collateral. They just grabbed it one day, froze up his construction project. He now lost the construction project to the bank. They cut off his funding. They said, we felt our collateral was in jeopardy, therefore we seized your account because you had it on deposit with us. And when you signed that loan, that gave us the right. But he sued him. He won. Okay, in February, March, just this last month and 2 months ago, he beat him. Took him 2 years. They held on to his money for 2 years. He was this close from going bankrupt. He's been spending all of his other reserves just to cover everything because of what they did to him. But he won because they didn't give him any notice. You had to give notice, and the bank did not give him notice. They just took the funds with no notice, and so he was able to get his money back with interest. But that's something that concerns me. And when I opened up a recent account, I bought some property, and this lender came to me and wanted me to switch over my law firm account to him. I wouldn't do it. He wanted my banking for the law firm, and I explained to him that you could take my money. He said to me, I would never do that. Okay, well, is it your decision? No, it's not your decision. So somebody above you could decide to take my money if they felt that the equity in this property has gone below their values, debt to equity ratio, and there's nothing I could do about it. Is that not true? No, that is true. Fine. You cannot have my business. And so this is a far field, but I'll just tell you, if you ever get into this situation, banks may ask you to put some money on deposit with them in order to obtain a loan. What I will do, I've done this many times, I will put on deposit whatever they require of me. For example, if they say, Clint, in order to give you this loan, we want to see $50,000 on deposit. Okay, $50,000 now on deposit with you. I receive my loan. 30 days later, there's only $5 on deposit with them in that account because I pull it all out. Because at that point in time, I have my loan. They cannot force me to keep my money there. And so I can go pull my money back out because I'm not going to leave my money on deposit with them at that point in time because I know they can pull it. And in this environment, it's a little tougher with banks and the way they operate. So control over your wealth. Yeah. Oh yes. Question. Let me pass the mic back there so everybody can hear it.
Yeah, when you have I've got a Wells Fargo bank account also. If you have multiple accounts with Wells Fargo, if you have LLCs or whatever, personal accounts, and you have multiple LLCs that you were talking about as far as real estate is concerned, sometimes if you move money between accounts, if you have trouble with one account, sometimes they can lock up all your accounts.
Yes. If there's problems with one account, you may find all accounts be locked up. I think that is an issue that could occur. I've never happened to me, but I could see that. And a lot of that becomes from the fact that your name is associated with all of those accounts. So one happens, it's a domino effect. Banking isn't perfect. A question or a comment that's made oftentimes is, Clint, the banking system in this country is going to collapse. What can I do to protect my money? What accounts are going to protect me? People are looking for FDIC insurance. It's $250,000 on an account unless there is no interest. It's a non-interest bearing account, and then it's unlimited. But that aside, Look at the practical matter of this. If the Bank of America collapsed, what does that mean for the rest of the economy in general, or the U.S. government? Yeah, it collapses as well. So you can say, I have insurance, but if the government has no money to pay you out, you have no insurance. So when you talk about literally too big to fail, the big banks in this country now are at that point, and they're too big to fail on a global scale. It's not just the U.S. that would be affected by this, but all the major countries around the world would be affected because of the assets these banks hold. So I don't see that as a real threat. I see inflation as more of a threat than anything else to your wealth, but not bank collapse. All right, so control. We set up an LLC to control your wealth as well. Why? Well, for many situations, we create a limited liability company, as we've just described. It's right here. You're up here as the manager of this LLC, and you're down here as what we call the members. Now, many times when we start out, it's just the two of us, but there may be children that we want to bring into our LLC, or grandchildren, because we don't want to just give them money. Because if you give them money, they can go do with it what they want. When I went to college, my father paid, when I say my father, it's actually my parents, but I use my father, paid for my college education. Now, he should have given me 1 or 2 rental properties. By rights, they're mine. With all the work I put in, I earned them. Sweat equity. But instead, I got an education out of the deal, is what he would say. So anyway, so the reason he should have provided me with 2 properties is so that I would have earned the money in my own name, and then taken those funds after I paid taxes at 10, 15%, and then applied them towards my college education and all my other expenses. Why didn't he do this? Didn't know. That's probably one reason. I think that is not the main reason. Wanting to control. That's exactly right. Here I am, 18 years old, going off to WSU, joining the fraternity the first year. If I had $15,000 to my name, would I A, pay for college, or B, pay for beer that would bring over lots of sororities? I'll tell you what, first semester, B seemed pretty good to me. Now, because he didn't give me the properties, he was able to come up to that school. I remember walking back from class one day, and there's my dad's truck. It's a 6-hour drive from where I grew up. And he's in my fraternity room, and he's sitting there with a copy of my grades. I hadn't shown him my grades. I always had an excuse as to why I couldn't send them over, because he wasn't around. So what could he do? Well, he got them. And the first thing I said, how'd you get those? You're not supposed to have that. That's a violation of my privacy. I tried, for what the heck? Everybody else screams that. I'll try that argument. That didn't get me anywhere, of course. So my dad told me that if I see anything below 3.0, you're going to pay your own way. So I'm not going to fund this lifestyle that you seem to be leading while you're over here. So he's able to control, and so he kept control of the properties. Therefore, he paid higher taxes on the income that was generated on those properties, because he's in, let's assume, a 40% tax bracket. So in order to have $20,000 as it was for law school remaining after taxes, he had to earn about $30-some thousand, $31,000, $32,000. Now, if I'm in a lower tax bracket, I would have to earn much less in order to go to law school, because less was taken out for taxes. So I have more after-tax income. He chose to pay more to retain control. Now, most people operate in that manner. A lot of people with the dinar have told me they intend to gift dinar away to somebody, but they don't know how much they're going to give them because of the RV amount, or they just want to make sure that they're mature enough before they give them the funds. Now, if you go about it that way, it's not a completed gift until they actually gain control of it. So in order to make a completed gift out of everything, you have to give somebody physical dominion and control over that currency. So if I walked up to my son and I said, here's $100, and I step back, now he has $100, he could go blow that. Now I might tell him, listen, I don't want you to blow it, because there'll never be another $100 bill coming your way if you spend it on things I don't want you to. And that might be enough to convince my son not to blow the money, because he would like to have another $100 in the future at some point in time. But if you give somebody $10 million and you tell them, listen, if you blow this and you do things that I don't want you to do, there'll never be another $10 million coming your way. They may look, forget 10 million, say even $1 million. If they've gone from having $10,000 a year as meaning a lot of money to them to having $1 million a year, they're going to figure, I don't need you. What do I need you? $1 million? I'm set for life. And that's how people think, especially younger kids. I remember when I was in high school, my girlfriend's brother was hit in a car accident. A drunk driver hit him. He got a judgment for $450,000. And I'm sitting in their house one day, and I was talking to her father, and he told me that he was giving him all the cash. I said, you're a fool. Well, I didn't call him a fool. I never said that to him. But I go, why would you want to do that? He said, well, he needs to learn about money. I said, well, don't you think that he's going to go blow it all? No, well, if he does, well, then he'll learn a hard lesson. And sure enough, within 6 months, all of the big screen televisions and computer equipment that this kid had spent his money on was back in that parent's house. Because he had moved out for about 6 month, 8 month period, spent it on boats, big trucks, RVs, jet skis, all this stuff, ran out of money and was back in the house. He went through $450,000 like that because he was too young, 18-year-old with that type of money. And so an LLC allows you to give them the money, but not give them the control. Control is everything. Ownership means nothing. I would set up an LLC with anybody, well, I wouldn't mind setting up an LLC and saying, I'll put in say 3 million dinar, you put in 3 million dinar, we'll hold it together in a limited liability company, and I'll let you own 84% of it. I want 16%, and I want to be the manager. Now, you might look at that and say, well, that's a great deal, because if you're putting in 3 million, you're actually giving me, what, 34% of that 3 million by contributing to that LLC, which I'm at 80%. But I became a manager over 100% of the money. And the reason I reserve 16% because the LLC operating agreement states that it requires a minimum of 85% of the membership to agree to replace a manager. I'm that manager. I hold that deciding vote if I want to replace myself. And I can tell you this, I like myself, so I'm not going to replace myself. So now that I'm in control of the LLC with all this money, you may own 84% of it. If I own 16%, take you out of the picture, it's just me managing it. Where do you think that money is going to be directed? Where I want it, because I am the manager of the company. So this is why when I talk about control, it's so important. Ownership really doesn't mean anything as long as you control something, because I could loan myself $6 million because I determine that's in the best interest of the company to give Clint a $6 million loan. Repay it when he feels like it. So I might be challenged on it, but do you have the money to challenge me? I have a lot of money inside of here to fight you if you come after me. See, that's something that sometimes people don't realize, is that when you're in a legal battle, it's not about who's right or who's wrong, who has the most money, who can fight the longest battle. So if I can keep fighting, then you'll end up losing just through attrition. So you expand this to another level, and we talk about control. If we brought in your kids, and this is so important, you have the dinar in there. So your dinar is in there prior to the RV. So here's my dinar. It's inside of that LLC. Then I've gifted away. I did this just yesterday. I met with somebody. We set it up. Their kids have some interest. We say we gave them each 10%, and the parents held on to 80%. Now, the parents are controlling this limited liability company as its managers. The children were told that they own 10% in this LLC. That's it. And they signed off on it that they accepted the interest. Now, they're the member in the LLC for 10%. But what is it other than a piece of paper that they hold in their hands? They cannot spend it. They can't do anything with it. So when the RV occurs, the money that flows into this LLC, let's assume that they had 3 million dinar, it revalues for $3, 9 million flows into this. 900,000 is taxed to the children because they own 10%. 900,000 is considered theirs for tax purposes, but how much can they get their little hands on? Zero, because it is you as the manager who will determine when distributions will be made. And something that sometimes people fail to realize is that you can distribute money to yourself and not to your kids. It does not have to be equal when it comes to distribution. You can say, we're taking the money, you're not, until things change in your life. And so that's when we talk about control, why it's so important to set these entities up, because you can maintain the control over those assets. All right, protection from your investments liabilities. Here's another benefit of a limited liability company. It protects you from what happens inside of the LLC. Now, here's an LLC that we've set up, and we place some real estate, which is a dangerous asset. When we talk about assets, we break them up into two different asset classes, dangerous assets and safe assets. You'll never mix dangerous assets with a safe asset class, because dangerous assets create liability for themselves. And that is, if something happens inside of here, inside of a box, everything inside of that box is at risk. So I may be down here as the owner and up here as the manager of this box. So I'm protected because the box forms a shield for me personally. So the assets stay inside of the box. If harm occurs inside of the box, it stays inside of the box. But anything inside of there is at risk. So you would never want to use the LLC you set up for your dinar to hold real estate, because real estate is an inherently dangerous asset. Somebody gets hurt on the property, they sue you. Now that you're being sued because of their perceived harm that occurred as a result of this property you own, everything that's inside of here is now exposed to that one lawsuit. So you want to keep assets separate, and you want to break them up. And so oftentimes you'll see that when we create these entities, we will create one LLC for cash and investments, your stocks, your dinar, and you can have as many accounts as you like in that LLC. You can have a bank account with Wells Fargo, you can have a Smith Barney account, multiple accounts, 15 accounts, there's no limit. But gold, okay, gold will go inside of here, silver is going to go inside of there in that one LLC. All that's in there because it's all safe. Now, I mean, think about it. What type of harm comes from my dinar? What could I do with that right now? I can go like this and grab out a note and walk over here and go, you're right on your bald head, and just do right like that, right? That's it. That's a huge liability for you. Probably more so for me, because you're going to bleed on this, and then I take it back. Now, the other issue you have, gold, what would you do? Oh, or silver, you get these 10-ounce silver bars. You're so excited about the RV that you go outside the building, you start dropping them on passerbys. Hey, some little extra wealth for you, right? And they hit them on their head. You see what I'm saying? There's no liability there. It's not going to happen. So the assets themselves are protected. Okay, the safe assets, you can group them. I don't see a problem with putting $10, $15 million inside of here. They're all protected. But when you get into the dangerous asset classes, then we have other problems over here. So we wouldn't want to necessarily mix a lot of dangerous assets together, because we're going to lose some of the protection we're seeking. That is, if I took 3 or 4 homes and put them into one limited liability company, it only takes one tenant to bring all 4 homes down. Is everything going fine, Greg? Good. Gotcha. Good. It only takes one accident to bring all 4 properties down in a lawsuit. So we will typically spread them out so you have multiple LLCs. And believe me, after the RV, and you have a lot of cash and you're able to do this, you should create multiple LLCs, one LLC per property that you acquire. So we'll put an LLC here, put an LLC here, put an LLC here. Now, Clint's down here. If something happens with LLC number 1, the most I stand to lose is just that one LLC, nothing else. Greg will talk about taxation of these entities tomorrow, but something else you should be aware of is that when you create these limited liability companies, you can set them up so that they don't have to file tax returns. They're just completely pass-through entities. They're single-member entities, so we can avoid, yeah, they're disallowed, so everything just flows right down on your 1040 Schedule E. There's ways to set them up in that manner. So really, they're set up, and as long as you operate them properly, which we'll get into tomorrow with the bank accounts and having tenants pay the LLC, As long as they're operated properly, you maintain the structure that we've created for you, you should have protection there. I use the word should because nothing is 100% guaranteed in this world, because you never know what jury you're going to pull. Yeah. The question is this: if you set your LLC up before it RVs, are you protected from taxes? You're not protected from taxes. When you have an LLC, it is a flow-through entity. So any income that is generated inside of this LLC flows out to you regardless if you distribute it to yourself or not. That's how a flow-through entity works. So you pay taxes on any of the income that's generated inside of it, even if it's not distributed. So the LLCs provide protection so that anything happens inside of that box will remain inside of that box and will not affect you individually. This is why they're typically created, for that one layer of protection. It's no different than a corporation. A corporation provides similar protections. That is, if I own stock in a corporation, the corporation is involved in some nefarious activity of insider oil speculation and creating, LLCs and partnerships to inflate their losses and produce higher income or whatever they've done with Enron. Company gets sued. Clint, the shareholder, is not dragged into that lawsuit. I'm protected as the shareholder. That's how an LLC works as well. It protects you from what occurs inside of the company. Now, it also provides a second layer of protection. Okay? That's my mother-in-law, by the way. I put her in her own LLC to protect me. So it protects your investments from your personal liabilities. Now, this is a big one. Your investments, we understand that when we buy things that, tenants or real estate tenants are an issue, or businesses, that creates liability for us, but you yourself create liability for all your assets. You're probably the greatest risk to what you own because you do things. You have kids that make mistakes like I used to make. And so this brings liability upon you. And so when we are boxing up everything that you own, and we're putting you down here, there's two forms of protection we're seeking. We're seeking what is called the inside protection that I just described, that is what happens inside of the box stays in the box. And we're seeking outside protection. That is, what happens outside of the box stays outside of the box. So it doesn't get inside of there and take our assets. For example, the currency that I'm holding right now in the dinar, that is owned by a limited liability company. So if somebody served me, and let's assume that they were able to serve me today, walk me into the room, sit me down, and then depose me, and they could force me to disclose what do I own. If they ask me right now, do you hold any currency in the Iraqi dinar? Do you own any currency in the Iraqi dinar? What is my answer? No. My answer is no. I own no currency. I do not. Well, you're holding on to it. I may be. You saw it in my pocket, but it's not mine. Okay? It's owned by a limited liability company. It's not owned by me individually. So you've taken the asset out of your name and you placed it into this company, and the company provides protections for you. And it provides protections at the legal level, that is the state level. Tomorrow we're going to talk about which states are better. I mean, we've told everybody to look at Nevada or Wyoming. I mean, the reason we chose Nevada is because you can see we have a huge presence here. These states provide a certain level of protection that is not offered by several other states when it comes to you being sued individually and whether or not they can take your LLC from you. See, with a limited liability company, the creditor that comes after you, they obtain a judgment against you. Here's how it works. We talked about the guy who has $100,000. Somebody sues him. They get a judgment against him for $1 million. They take $100,000 of his. Now they walk around with this $900K judgment surrounding him for the rest of his life. He's not too happy about that because he can't ever get out from under that debt. What this person will do, the creditor will do, they'll file that judgment in every state where he might own property. So whenever he sells that property or tries to transfer it, that judgment has to be paid off. It will attach to him. It is sticky. It's like glue. Now, if we're in a different situation and and we put his assets held in limited liability companies, then that judgment attaches to the individual, but not to the LLC. So the LLC could buy and sell property without any concern whatsoever. It can invest in currencies, invest in the stock market without any concern, because there's no judgment to attach. They could not take that judgment to the LLC and garnish the bank account. I mean, garnishments on bank accounts, that's like catnip to a plaintiff's attorney. If you have a lot of money in a bank account in your personal name, and I get a judgment against you, I'm running right down to the bank, slapping that garnishment, and your funds will be frozen and will be paid to me until that judgment's paid off. So what the LLC will do for you, when you own this LLC interest and you have all these assets held inside of the various companies, the creditor cannot take this membership interest from you. It can't become a member with you. So they have to stay at bay. Most, not all states have adopted this procedure, but Nevada has on their books, the law states that they cannot become a member with you, or they cannot take that interest from you. So the answer to that is no. You know, can the creditor make you sell the limited partnership or LLC and then give them the cash? Okay, that's another situation. The answer is no, you do not have to do that. So you're holding on to this interest and your creditor can't get after it. They know that that LLC may hold several $1 million in assets, but they cannot climb into the LLC and make you sell the assets and distribute the cash to them, because you're the one in control and they cannot take that control away from you. So the answer to that one, of course, is no. And then is, you know, can the creditor become a partner with you in your LP or LLC? The answer to that, I've already said, is no. Now here's something that will illustrate this point. I think last week I wrote a blog on Florida. Florida's LLC statute was brought into question 3 years ago. And this will illustrate how this works. There was an individual who was involved with a credit card scam of some sort, and I forget the actual details. One of those where, hey, you can sign up for a platinum card, pay me so much money, you get a platinum card, and they thought they were going to get a platinum Visa card, and you just sent them a platinum card. And so he made several $1 million doing this. Now, take the fact that what he did was wrong out of the equation, because that can sometimes cloud the way you look at things. And you look at the entity that he created, which was a limited liability company, placed several $1 million inside of it. The Federal Trade Commission, who originally brought this action, the injunction against him from engaging in this behavior, sued him, and they got this judgment against him in court for all these penalties for what he did. And they wanted to collect against his limited liability company. So they went to court, and they argued that they could take his LLC from him, that they could own the LLC. He'd have to give it over to them. And the individual, whose name is Olmstead, he argued that he has a limited liability company, and the law states that you cannot take somebody's LLC. So the issue for the Supreme Court of Florida was whether or not the law in Florida, the LLC statute, protects a member in an LLC from this type of attachment. That is, can they foreclose on his interest and take his interest away? Well, the court determined that Florida statute left that question open to the judges, and that they were free to fill in the gaps and make the law themselves, which they did. And they said, in their opinion, they stated that the limited partnership statute there provided that the charging order is the sole remedy available to creditors. Because the LLC statute did not contain the same language, they felt, in their opinion, that the court was free to give the FTC the interest in this LLC that was owned by Olmstead, because they fashioned it as personal property, and personal property can be attached by a creditor. So Florida gave that interest away. Now, what that did is it sent a tsunami through the legal community when it comes to asset protection. They became really concerned about what are the long-term implications for people in Florida, because then all LLCs now are called into question. In fact, I told many of my Florida clients, we sent them emails, hey, if you have an LLC in Florida, you might want to consider moving that interest into a Nevada holding LLC, because if you get sued, there's no protections any longer in Florida, or convert it to a limited partnership. Well, Florida just changed their statute. Now, if you have an LLC with more than one member, you have protections. But if it's just a single member LLC, they can still give it away to your creditor. So when we're looking at these protections, they're not uniform in all states. And Florida is an example of where if you set up an LLC there to own real estate and you're the only one owning it, and you get sued in Nevada, they could potentially go to Florida and take that LLC from you. So you wouldn't want to own it. That's why it's important that you know the laws of the different jurisdictions where you're forming limited liability companies. So we will tell you. Yeah, the question is, do you have protection here in Nevada on the single member LLC? Yes, their statute states that the charging order is the sole and exclusive remedy. In that opinion that was handed down by the Florida Supreme Court, they actually referenced the Nevada statute. And they said, here's language we have in similar states where they show that it's the sole and exclusive remedy. We do not find that in our statute. Therefore, we feel that this is personal property and we can levy on it similar to what we could on stock in a corporation. So there's no protection in that instance in Florida, but here you do. So what happens? What are the protections? Only the charging order. Now, what the charging order provides you, and this is why we told everybody that we talked to, if you want protection, you should put your currency into this LLC. Or I'm going to tell you something else now that was brought up the other day about trust, but let's just focus on this. The currency should be placed inside of this LLC because if somebody sues you individually, the creditor cannot do any of the things that we just described. Okay, can't make them a partner, can't demand income, can't do anything. All they can get is a lien. So if I have a limited liability company set up here, it has my dinar, my cash inside of it. I'm up here managing it, and I'm down here as the member of my LLC. What they're going to do, that is the attorney with the creditor, they're going to put a lock on my ability to pull cash out of here. And that lock, what is going to happen is if I make a distribution to myself, and there's this dog over here that sued me, all the distributions have to go to him until the judgment's paid off. So I have to keep paying that dog off, keep paying him off. I take distribution. So would you take a distribution out of your LLC if you had a dog like that sitting around waiting for it? No, because we're not going to feed them. Now, first off, that gives you tremendous amounts of power because you could walk up to your creditor and you could explain to him the situation and you would say to him, listen, I understand you found a jury pool that doesn't understand real world and money and how it works, and they fell for your game and they awarded you $2 million. But we both know that you're not hurt to that extent. And I have no qualms about making you whole. In fact, I believe that if I injured you, it is my responsibility to bring you back to the level you were before the harm occurred. But it is not my obligation to allow you to profit from my mistake. And that's where the legal system has gone awry. That if you're injured, now we have this sense of entitlement that I'm entitled to profit. So are the attorneys. So here's what I'm willing to do. Rather than give you the $2 million that you were awarded, I'm going to offer you $200,000, which my experts determine that is the level to which you were injured. Will you accept that money? Now, if they choose to not accept it, then you don't do anything. Say, fine, conversation over. Maybe sweeten. All right, I'll give you $300,000. They may say, well, I'm entitled to $2 million. Why would I accept $300,000? Because I have a limited liability company set up here. And whether or not you understand this or not, because I doubt your attorney has taken the time to explain it to you, only remedy you have is a charging order. The charging order only allows you to be paid when I take distributions from my LLC. So you think that I'm going to distribute $2 million out of my LLC tomorrow so you can get paid? You think that is reality? It's not happening in my world. I quit talking to them. And then you could go out there and conduct your business in your LLC, reinvest the money. You could set up another LLC to hold property, move money up into that LLC. This LLC, of course, is owned by this LLC. Oh, you could do, yeah, okay, so what the question was this, or you could possibly do this. You have one LLC here with the dog on it, with the lock, all right? So you have money here. You could set a second LLC up over here that you own, and you can loan money to this LLC to buy a piece of property, and then the rents could come out to you like that. They may not know about this LLC. That's what you would do. You get the mic though, so people on the internet can hear. Turn it on. That black button right there.
Okay, the question is this: if you move cash from a personal account into an LLC, is it a taxable event?
If you move cash from a personal account into an LLC, it is not a taxable event. It's a capital contribution. That is why when you contribute your dinar, even if we've had the RV and you've not exchanged them, moving those appreciated assets, currencies into the LLC is not going to create a taxable event for you. So you can move assets in and out of limited liability companies, provided they're not treated as corporations for tax purposes, and it's a non-taxable event. So in this case, you have the funds, you could have access to it. But now, after a year or two has gone by and your creditor is still sitting around waiting for you to distribute some treats to them and you have not, maybe you walk up and say, how you been doing? How much money have you received from me recently? Well, that's right, I didn't distribute any money to you this year. Is that what you thought when you won this lawsuit, that I was just going to distribute money? What did I offer you? My memory's not so good after this lawsuit. I've burned a lot of memory cells. What? You say 300,000? No. That was at the beginning. Now I'm going to offer you 50. Okay, now I'm going to give you 50. You want to take it, or you want to keep playing this game? So you reduce it, incentivize them to make a decision. Now, if he steadfastly refuses and he wants to play a game with you, that he's going to keep you tied up, and he has an attorney that's just as aggressive, and that's when you bring out this and you throw it in front of him. See, do you understand under Rev Ruling 77-137 that as a creditor of mine who's placed a charging order on my limited liability company, you are responsible for my taxes? Just on the LLC, of course. What does that mean? LLC is a flow-through entity. You put money inside of here, your dinar, it RVs, and you trade it in, and you generate $3 million. Say you had $1 million dinar, it comes out at 3. Now you have $3 million cash. Forget about long-term, short-term, it doesn't matter. You have $3 million cash. That is taxable to you. If you own the LLC, you will pay tax on $3 million come April 15th the following year. Plain and simple. Now, if somebody put a charging order on my interest, and this occurred, I'm going to wake him up to the fact that in this Rev ruling, he's going to receive a K-1 from my limited liability company, which is also going to report this to the Internal Revenue Service that he put a charging order and he's going to be responsible for my taxes. Now, if that doesn't get him going, then I'm going to show him some of the language. Each LLC that we've created for people, I don't know if we've created all for you in here, your LLCs has language similar to this, not this exact same language. It says the assignee of a membership interest as well as any person who acquires a charging order against a membership interest shall report income, gain, losses, and deductions and credits with respect to such income interest. That's when you slide that piece of paper over in front of them and say, see what my operating agreement says right here? It reads that you're responsible for my taxes. And by the way, look what Rev ruling 77-137, it agrees with this. So by placing a charging order on my interest, you've turned my LLC into a pension plan. What is a pension plan? That is something where you can sell assets and you don't pay taxes until you pull them out because you're going to be paying my taxes. And here's what I plan to do over the next year and a half, or as long as you stay here. I'm going to generate lots of taxes. I'm going to buy and sell anything I can think of that will generate a taxable situation for you to make your life a living hell like you did to me for the last 2.5 years. That's how I'd mess with somebody. Why not? And so if you were on the webinar, you saw, I mean, what I referred to this as, if once you put this in front of most attorneys, okay, they're going to smell it and they're going to disappear, okay, because they're not going to like it. It's called attorney be gone. Now, I know that's cute. The thing about it, people will ask me, Clint, come on, does it really work this way? Well, having had, I mean, we have a lot of clients, 17,000 clients. How many of them have been in a situation where somebody's placed a charging order on their interest? I don't know of one. Not one of my clients have ever contacted me and told me that they've been in a situation where they broke their LLC from a personal judgment and placed a charge note on them. Not one. Now, further evidence of how this works is that there are not a lot of legal opinions regarding charging orders. See, if this was something that was taking place on an everyday basis, like what occurred in Florida, the Olmstead, there would be appeals. The individual who has the assets does not want to lose them would appeal, and then you would get an opinion that you could read as an attorney and say, oh, that's interesting. But what occurs, and this is not only from my own deductions, from just the law in general, how few cases there are out there, I have talked to attorneys who sue people who are plaintiff's attorneys. And the question I ask them is, what do you do in this situation? If you know that they have limited liability companies set up, what do you have to do? First word is settle as quickly as possible to get as much as I can, as quickly as I can. Because there's a point where there's a lot of diminishing returns. We know that the more we push them, the more steadfast they're going to be about settling. And at the end of the day, if all their assets are protected, we can't get anything from them because of the way they're set up. In fact, there's an attorney he's a friend of mine. He lives in Savannah, Georgia. His specialty is head injury trauma. He's a personal injury attorney. He has judgments of over $10 million. I think his highest is $17 million. And yeah, he makes his money that way. I mean, everybody knows him. You go down to Savannah, Georgia, because he does a tremendous amount of advertising, all the phone books. The police department down there thinks it's great because each year he comes out with a new magnet that people put on their refrigerator. And the police department, when they raid crack houses and everything, they're always grabbing to see who can get the most spiva magnets, is what they call them, for the different designs. It's become a little cult thing in that area. But the way I met him, seminar, workshop just like this, like I think it was 2002, came up to me and said, this is what I do. I take people down that you're trying to protect, and I know what can be done, and I want you to protect me. And then, so I created structures for him to protect him from the other people out there that are like him, and then we became friends after that. You know, I think most of the cases he brings, they're legitimate claims. People are really injured. But, you know, the 17 million, I don't know. He lives a good lifestyle. So it's protection. So limited liability companies or limited partnerships, depending on what you said, what are they set up for? Currency, of course, real estate that can be used to protect, brokerage accounts, savings, equipment, vehicles. Just about anything that you want to protect should be placed inside of these vehicles or of these entities. But they would go in there based upon their asset class. We don't want to mix everything together. We want to break it up. So again, if we looked at our assets, initially when I asked you about asset protection, you threw out there hard assets, cash, stock, dinar, businesses, things I have here, real estate. So how would we go about protecting them? Well, as I stated, I would create one LLC, make sure this one's a Nevada LLC for your dinar and for your cash and savings. Now, see, this is what comes up a lot when I'm dealing with a client. I will fill out their LLC. I create the LLC. I ledger over the dinar for them. Now, how do you do that? Well, in your limited liability company agreement, it's really important that you have certain documentation. For example, that clause that I just showed you, if you don't have that in your LLC, then you don't have those protections. You have to have these things in there if you're going to rely upon them. People will call me up, and they already have set up a limited liability company. And they'll say, well, I want my LLC to own my dinar. Okay, well, then you need to ledger it in. Well, where would I do that? I don't know. I didn't create it. There should be some ledger inside of there that allows you. No, I don't have anything like that. All it shows is many times just a filing, or I just have a membership agreement where I signed, and that's all. It's about 8 pages long. Well, that's a problem. You should have a sheet that for each member that shows what they're contributing. So we have an asset contribution. We call it Schedule A's. We have Schedule A. So if there's 3 people involved, it'd be A1, A2, and A3. And on each of these schedules, I would list what they contributed. So husband, if he moves, if say a family has 10 million dinar, I would put on here, this is for husband, this is for wife. I would have husband contribute maybe 5 million, Wife's schedule, we list 5 million dinars. So I list the dinar. It says 5 million dinar. I don't list serial numbers. Have you ever look at your serial numbers? You can't read them. Greg, about 3 weeks ago, really scared me. He got a call from somebody who said that this person had called him up. She said that she was looking at her dinar, at her serial numbers, and they're all the same. And so my safe's right there next to where I sit. Okay, gotta protect it, right? So I reach in there, reach behind the little silver and gold bars I got in there, and I pull out the dinar, and I start flipping through it. I said, oh man, where'd you get it? Because I think I have the same problem here. And so I go into panic mode because he'd already planted that seed into my mind that these things are the same. And then Greg looks at it. I don't know if he'd set me up intentionally. He said, well, Clint, you have this weird number that goes like this, and there's 7 and then a dot. Well, then you look at the next one, the same weird number, and then the 7 goes like this and a dot. The 7 was transposed. And then you see another one, it looks the same thing. There's a 7 and then one of these in front of it and then a dash. And so all the serial numbers, I don't know if you ever looked that closely on your dinar, they look the same. They literally do. When you start flipping through them, you're going to think that somebody sat there at the printing press and they forgot to change numbers. I mean, when I bought my first million, that was my initial concern. That's why I got it and smelled it and rubbed it on myself. It feels like real money. So anyways, I wouldn't list all the serial numbers. That would be, you couldn't do it. I mean, like that. So I list the dinar, how much you've transferred in. I transferred in 25 million dinar. And so you put that in there. Then you sign that this is what you contributed on the membership ledger. This is how you get your money into your LLC, is by listing this. And so the wife was 5 million. And then we have the child over here to whom we want to gift. So now we'll gift the kids the interest in the LLC. So now they have their own schedule. So when they have money that goes in their LLC, it goes on this schedule right here. So each member has their own schedule associated with their membership interest. That is how you fund an LLC with your currency. It's documented because that's the only way you can show documentation. Other than the fact you have actual possession, there's really no other way. And that's why if you were on one of the webinars, I talked about gifting. What are the elements to gifting? Intent, delivery, and acceptance. Intent, delivery, and acceptance. That's the only way to make a gift. And so many people have told me that they have filled out a piece of paper that stated that they intend or they're gifting so many dinar to this individual. And I'll ask them, who holds the dinar? I do. Well, then it's not a gift. Well, I signed a piece of paper. I know, but does that person actually have possession of them? If the person does not have possession, then they cannot spend them. They cannot turn them in. So you've not completed that gift. You actually have to give them the dinar. Now, what is the importance of the letter? Well, the importance of the letter is to establish the date the gift was made. Because if the RV happens and you're subsequently audited and you've gifted to somebody 1 million dinar, the IRS, let's assume again, we'll just use that $3 number, the IRS could say that you gifted them the dinar after the RV. So you made a $3 million gift to this individual, not the $3,000 or $3,500 gift that you allege that you made prior to the RV. Because prior to the RV, 1 million dinar, it was 1 million dinar, not 3 million. So 1 million dinar right now is worth about $1,400, $1,200, except that the smaller denominations, I heard those have really gone up in value.
So it depends on retail versus actual. Actual value is still $855.
Okay, so you have it. So let's assume that you had $855 to $1,200, whatever that is. That's the gift that you make when you transfer 1 million dinar to somebody. You've just gifted them something under $1,500. That is a non-taxable event. Each of you can gift away that type of money to anybody you want each and every year. Okay, that falls within your annual gift exclusion amount. Now, when that recipient takes that $1 million and they exchange it themselves, they generate $3 million in taxable income. That is taxed to them. It is not taxed to you because that is their asset. That's why with the LLC, one of the reasons we set the LLC up in the manner in which we did is to have some of the money taxed down to our kids, so it makes it their asset. Well, the IRS might say, if there's not supporting documentation, that you gifted the currency after the RV. You held on to it with the intent to wait to determine what the amount was going to be, and then you decided how much you want to give. I've talked to quite a few people who said, oh, I intend to gift them anywhere between $1 million to 3 million dinar, but I don't know yet. Why don't you know? Well, if it comes out at $3, I'm okay gifting them that 3 million dinar. But if it comes out at 50%, they're only going to get $1 million. So you haven't really gifted anybody anything yet. So that's what could be argued. So by having that corresponding letter, and then ask them for a receipt. Ask the person to whom you give the interest to a receipt. I mean, you shouldn't gift them dinar outright. You should, well, some of you will, but for family members, run it for the LLC, and that could be brothers and everything in there. Have them acknowledge receipt via an email. In fact, I would send them an email saying, hey, I'm sending you the following amounts of dinar. Here's what I think about it. I want to gift this to you today. You'll receive it in the mail. You send it certified and keep that certification. And then have them, once they receive it, send you back, yes, bless you, send you back a return email stating, yes, I received it, thank you very much, something like that. And now you have this trail that if you were ever audited and challenged on when that gift was made, you can establish, yes, I made it prior to the RV, because that's when I moved the money to them. Of course, they should be the one cashing it in as well to further evidence that.
Well, actually, the issue doesn't fall on the giver, it falls on the receiver.
No, it doesn't. It falls on the giver.
Well, no, to prepare the document, but in other words, to make sure that you filled out documentation, gifting it to them so they have some proof when they go to cash.
Correct, but the tax falls on the giver. Question was, who pays the tax when you gift currency to somebody? The giver pays the tax, not the recipient. So the first going to go after you, so you would be the person responsible for the gift tax.
So the question is, if we set up the LLC pre-RV, we fill out these forms, we put our kids' names, and we also in the LLC have said that we got these letters saying that we're gifting X number of dinar, and we hold it through this asset form that says they are ownership of that. We put all of it into our bank safety deposit box, which is our business account for the LLC. Does that still constitute they have control and delivery? If it's still in the bank account for the LLC.
So yes, you gifted them the interest, because when the cash is in the LLC, you're not gifting them the dinar any longer. You've converted dinar into a limited liability company interest. And so now I'm not gifting you the currency. I'm gifting you something that represents the value of that currency, which is the LLC interest I've just provided to you.
So that's really what it is. It's the value of the LLC.
It's the value of the LLC. So that's the completed gift right there. So for your asset protection structure, again, pretty straightforward. You have your SAFE LLC right here. It's in Nevada. And then you create what we call danger LLCs for all of those assets that are dangerous, and you put those in the states where the property is located. And Greg will talk to you about something tomorrow about using a holding LLC, where you can wrap these LLCs into a big limited liability company for additional layer of protection. And so it's beyond what I'm going to cover today, but that's what we're going to hit on tomorrow when we break these things down, show you different structuring matters that you would consider. Because you don't want to go out there necessarily after at RVs and you're looking at creating additional LLCs and start owning them in your own name. If you can set these up in, say this was in Florida right here, and this one's in California, and this one's in Oregon. Even though those states do not allow you to create an LLC with a nominee manager like you can in Nevada, I can still master ownership. by doing it a certain way within Nevada LLC so that your name will not appear on those companies that we're creating for you. So even though it's an in-state LLC, you still have privacy. Now that is something we're going to go into tomorrow, but that's something to consider. So these strategies, you have to know that, yeah, it's great, you have to set them up, but do it in the right manner so that privacy shield stays in place. Okay, so step 2, control over your taxes. First step in this investment is protect yourself. Number 2 is to reduce your taxes. So which way do we go? Do we just go and transfer the money and pay for it, in our own name? For many people, the answer to that question, when I talk about RV, do I RV in my own name or in an LLC that's going to flow down and be taxed to me? The answer to that question is yes. For many people, that is the way to go. So this is tax to me. Well, most of you are going to go this route, where you're going to set up an LLC, you're going to put your dinar in here, and then you're going to RV out and have the cash flow back in, and it's going to be taxed down to you. For many people, that is the route to go. There is no tax savings in that strategy. It's just something the way it is. All flows on your personal return. The LLC does not eliminate tax, does not minimize tax. Now, there's some people who will have you take the purple road. And the purple road is through the creation of a corporation to minimize taxes, a C corporation. I would not go on the purple road because the purple road will lead you to higher taxation because the income that is generated inside of the corporation is taxable at the corporate tax bracket, and then it'll be taxable to you at your individual tax bracket when you pull it out as a dividend. So I would avoid the corporate road to go that C corporation route. Now, there's this middle road right here. It's for the CRT. There's one other side road here we still have to talk about, but let's talk about the CRT route. We'll go into that in more detail tomorrow, but the question is, should I create a charitable remainder trust? And for those of you not familiar with this entity, it's an entity that allows you to move your currency before it's been exchanged or before it revalues or after it revalues, before you exchange it into this CRT. You put it inside of there, and that's where the exchange will take place, inside of the CRT. Now, just as I described with the LLC, the way you get money into an LLC or dinar into an LLC, you ledger it. You do the same thing with the CRT. You fill out a ledger for your trust, and you say it owns $5 million. Now, once it's inside of there, it's ledgered in there, you take it down to your bank, and you exchange it. The money will flow into the CRT. The money that flows into the CRT is not taxed. It's not taxed. You cashed it. The question was, even though you cashed it in the name of the CRT, not in your personal name, not in your LLC. So the money from the bank, if this is the bank right here, bank, say it was Chase, they will send the money to this CRT. So the CRT receives the funds. Never touches your hands. If the cash came into your account, then went into the CRT, that's taxable to you. It has to go directly from there to the bank to this CRT to avoid it. With the CRT, then you pay tax when the money is distributed out to you, as Greg's going to cover in more detail tomorrow. But what I want to explain to you is that when is this middle road appropriate? It's appropriate for those individuals who have sufficient amounts of income on the outside and assets to do with what they want, that the money they're considering putting in the CRT is not something that they're going to rely upon or need to rely upon for their lifestyle. Because the CRT, the payout, is going to be limited based upon a number of factors. And if you find yourself in a situation where you need cash, you can't walk up to the CRT and just pull out gobs of cash. It doesn't work that way. Because it'll create, it's been pledged to a charity with you, and you're getting a lifetime interest in this money. So you can't treat it that way. Whereas if I have a limited liability company set up, I can walk up and pull out $5 million just with the stroke of a pen. And there's no tax ramifications to me. But with the CRT, there can be significant ramifications if you destroy it in that matter. So This option is a viable option for people. I typically tell them over 3 million dinar. Because I assume for most people, their first 3 million dinar, assuming that it's an RV rate of somewhere between $1 and $3, you're going to want to keep that in your own name. There's things, debts you want to pay off, houses you want to buy, so you'd keep that there. Then anything above that, then we can explore it. So it's an option. It's a way to defer tax, but not eliminate tax on the RV. Tax deferral is a great way to go. I mean, there's three tax systems in our country. Pay now, which is your salary. Pay later, which is tax deferral. IRAs, 401k plans, CRTs, that's a pay later plan. It allows you to grow your assets much faster because the government isn't taking a piece of them on an annual basis. It's only taking a piece when you distribute the money. Or there's never paid taxes. And that's not, go here to Nevada and sit behind a cell in an orange jumpsuit because you're a tax cheat. It's because you're deducting things. And so tomorrow we'll cover some deductions and stuff, running businesses or what you might want to consider to help reduce taxable income. So this is that middle road, pay later. Now, there's another road out here that I've just put on there. And I want to talk a minute about trust, because there's a lot of information out there regarding trust. And talking to our CPA here today, discussing irrevocable trust. Now, let me tell you something about an irrevocable trust. I've listened in on a few calls, as I'm sure you have, where somebody pitches an irrevocable trust. And I've received quite a few emails from people who've spent money on these trusts. Okay, the names all confuse me. Get Team, I didn't know Dan's name was Checkmate. People say, oh, Checkmate. Well, who's Checkmate? People have handles. Anyways, I'm not going to call it, well, it could be considered a scam. The way it's pitched is that if you create an irrevocable trust, you should do this. You should take everything you own, your car right here, it's going to go in a trust. You want to put your house, that's right, in a trust. You want to put your vacuum cleaner in its own trust. Literally, people say, everything I have, I bring them up. Cash into a separate trust. So you can create, there's one group out there, an individual who will sell you 10 separate trusts. Is that his name? For $3,000. And you can, and I asked this individual bottom, I said, why not just buy one and copy it 10 times? Well, he doesn't sell them that way. Okay, so he took one and copied it 10 times and sold it to you for $3,000. And it came with all of these attorneys' so-called opinion letters. Well, I read through the opinion letters with this particular trust, and the letters, the main letter was from a deceased attorney who passed away in 1986 out of Texas. That really doesn't carry a lot of weight for me because you can never go back to that attorney and hold them accountable for any misstatements of the law. But what sometimes people fail to realize is that when you receive a letter written by an attorney, it may appear as if it states a lot, but it really doesn't state anything. Attorneys have an ability to be very creative in their writing. And so I can fill up 10 pages, and it means nothing. That's right. So I would become politicians. So I know that's why I get frustrated listening to them, because they never seem to say anything. Well, that's what a lot of these letters that I've read state. Well, a trust is this. So they repeat what a trust is. Great, I know that. But are you telling me that this trust, as it's been represented to my client, will absolutely provide asset protection for them in the situation that they would describe? Because people are told to do this. They're told to create a trust. So this is you. You're the grantor. You put your assets into the trust, then you become the trustee, and you become the beneficiary of that trust. Now you have asset protection because you've taken it out of your name and you've put it into this trust. This is now called a grantor self-settled trust. And in fact, I think they actually use that term. Create a grantor self-settled trust based on Scots on trust law is one of the individuals that promotes these things. The problem with that is that you do not have asset protection, number one, because it's a grantor self-settled trust. You cannot put assets into trust for yourself and control them and receive any form of asset protection. Now, you could put assets in trust for a child or for a spouse and control it. You're not going to be the beneficiary, and then you could have asset protection for that trust. But for you, it would not happen. Now, another problem that I see in this type of planning is that you are told to place all of your assets into these trusts, create multiple trusts and protect everything that you own, down to the equipment trust that holds your vacuums and computers and televisions. That smacks of fraud. If you're involved in a lawsuit and you come into court and you tell the judge that he may grant the creditor a judgment against you, but he cannot take a single thing from you because you've created trust to protect even the clothes you're wearing today. They're owned by my clothing trust. What do you think the judge is going to say to that? What's wrong with you, boy? Why do you need to go to all that trouble to protect even your clothing? Did you know when you put that suit on today, you're going to go out and do harm? And you want to make sure you're going to stay clothed for the rest of your life? I'll tell you how we'll clothe you. Okay? Yeah, size extra large orange. It comes in, just one size. And you get a pair of slippers to go with it. That's what you're portraying when you go to this length. And so by putting all of your assets. So you have not seen me today tell you, create an LLC for your personal car, for your personal effects in your house. I'm not telling you that because that's not what you should do. Assets or LLCs, anything you create must have a specific purpose in mind, business purpose in mind. It cannot be for personal benefit only, because if it's for personal benefit only, you lose the shield. One of the reasons why I tout Nevada for LLCs for the dinar investment is because Nevada does not have a business requirement here. A business requirement is extremely important when it comes to asset protection. If somebody's trying to pierce your LLC, that is, they sue you and you claim LLC protection. They claim your LLC is not a valid company because it does not operate a business. All it does is hold currency. It's called a reverse veil piercing. Now, you stand back and you say, you're right. If I was in California, you could break my LLC for that particular purpose. However, this is a Nevada LLC, and Nevada does not have a business purpose requirement. So great, I can set one up for any purpose whatsoever. It doesn't matter. So that's important in choosing the jurisdiction, whether or not there's a business purpose there. But you don't want to take personal assets and hide them, because that smacks of an individual that is planning to potentially do harm, because they've gone to these great lengths. So keep personal, business, investments separate. Now, you've also been told on some, I would listen to one call, and I forget who this guy was. He stated that a trust, you can exchange your dinar at their RV and you will not pay any tax as long as it's held in the trust. Now, I've thought about that. An irrevocable trust. That's right. He said it was an irrevocable trust. And I thought about what he meant by that. And I think it's a matter of a classic sales pitch. That statement, if you take it separate and apart from everything else he was saying, is a true statement. If you place your dinar into an irrevocable trust and you exchange it inside of that irrevocable trust, you will not pay any income tax. The trust will. But that's left off sometimes. Now, I've heard another person actually say the trust won't even pay tax on it until it distributes the assets to you, that you can exchange it and no tax is due until you actually pull it out. No, that's not true at all. Either you're going to pay the tax or the trust is going to pay the tax on this income. So from that standpoint, When I hear that, I tell people, no, the irrevocable trust is either going to pay the tax or you're going to pay the tax on those funds. If it's a grantor trust where you're in all three positions, you'll pay the tax no matter what because it's all going to hit your return. But there's something else to keep in mind here. And, well, let me go back one other point I want to make. If you set up a trust and you're seeking asset protection for something in which you've set it up, an irrevocable trust, that is, I want to create an irrevocable trust for myself, then in order for that to work, you have to set it up in one of the jurisdictions, such as Nevada, that permit asset protection trusts. They're called APTs. APT is the acronym for them. And what would occur in this situation is similar to your situation with your wife. You have to name somebody else as the trustee, so that cannot be you. It has to be somebody else that resides in the jurisdiction where you're creating it. So it'd be a Nevada person, Nevada Asset Protection Trust. So okay, so you have a Nevada APT. So, all right, so you are down here with your APT. Pretty close. Now, okay, I'll give you one. Now, you've got somebody else as a trustee in Nevada. Okay, any relation? I can tell you've got a full head of hair. That's what you get for sitting in the front. So he's your trustee. Now, here's what could break down. You have to be aware of it. He cannot be controlled by you. If you go to him and you say, hey, buddy, I need some cash. Send me some money. Then you lose the protection of the Asset Protection Trust, the statute. The statute provides that you can have this provided the independent trustee makes decisions with regards to distribution separate and apart from your influence. Otherwise, that disappears. The Asset Protection Trust itself, as you probably already know, does not provide immediate asset protection. There's a 2-year look back on that protection. So they have to season for a while. Now, let's assume we've met these requirements for asset protection. At that point in time, asset protection trusts, they do offer really good protection. I mean, it's one of the best types of protections you can get. But the problem is that you have to turn over control to somebody else. Now, how well do you know him? Well, good. Then you better be concerned about it. You know, I'm just joking with you. But your trustee could abscond with your money. And I've seen situations where people have lost money in a situation such as this where the trustee took off with their funds. So you have to really trust the person you use. Many times people will use a trust company or an attorney because they have licensed and bonded and insurance to serve as their trustee. But again, it comes back to control. I'm willing to sacrifice a little bit of protection on that spectrum in order to be in control of my own assets. It's really how, I mean, I feel control is so important. So there's some misstatements regarding the actual asset protection that come from these types of trusts. Now, this brings me to my last point on these trusts that I was talking with Steve about today, and that is when might an irrevocable trust set up the proper way benefit somebody? If you've heard me on any of the calls in the last 2 months, I've really hit trusts hard and told people not to do them. I went overboard in the way I approached these. It was intentional. The reason I intentionally bashed them to the point that there's nothing left and why people didn't consider them, they're afraid they would go to jails, because many people that I ran into were making a decision that would prove to be unwise down the road because they didn't understand what they were doing. And the people that were promoting them were doing it in such a manner that were leading you to believe you had protection, you didn't have to pay taxes. I don't want to see you go to jail because some guy that you heard on a call sold you a product and you can't find him any longer, and you're the one that the IRS is going after. So sometimes we take the approach where we're more aggressive in how we address these. Now, if you approach this with a little bit of knowledge and you understand what they can and cannot do from you, there is a potential opportunity for you to couple a trust with an LLC. And here's why it might work in your benefit. It is for those individuals who live in a state that has a personal income tax. And this is not my idea, by the way. This was brought to me by a client, and I hadn't even thought about it from this perspective. It was just brought to my attention this week. And I talked to our CPAs down here today about it, and he said, yeah, that's a great strategy from his point of view. It could work. Now, I'm not saying it will definitely work, but I think you might, if you're okay with taking on a little risk, knowing what the ramifications are, maybe you want to consider this. Here's the thing. When you create a trust, an irrevocable trust, we'll just call it an IT, it's set up right, the right way, what's not considered to be taxed down to you and ignored for tax purposes. And you put your dinar inside of there. One of the things you have to realize is that on your first $11,000 in income, after the first $11,000 in income, everything's taxed at 35% in the trust tax rate. Let's assume you've held the dinar for less than a year. You're going to be taxed at 35%. So the taxes are the same. If it's taxed to the trust, it's taxed to you, it doesn't matter because you're both at that 35% bracket. Future years, that could be a concern for you because in future years, when you earn, your trust earns maybe $100,000 or $200,000 on some of its investments, now it's taxed at 35%, where your marginal bracket may be much lower than that, or maybe lower than that, maybe at 30%. So now you're paying more to have your funds in this trust. So in future years, it could become a problem. But here's how a trust works from a tax standpoint. This is important to understand. If the trust pays tax here, and you're down here, then when it distributes money to you, you don't pay tax because it's already been taxed up here. So if you're receiving principal distributions or after-tax distributions, you're not going to get taxed twice. Now, it used to be in this country that people would create trusts because the income tax bracket in the trust was lower than their personal tax bracket, and so they used it as a tax avoidance or tax minimization technique to pay lower tax up here than distribute the money to them after taxes. So if their personal income tax bracket was at 70% or 60%, when our income tax brackets were higher, trust tax brackets were lower, they'd say, I'm going to eat the tax here and then distribute the remaining to me, and I just save myself 15, 20%. Well, Congress stepped in. They said, no. What we're going to do is discourage the use of trusts by putting the highest income tax bracket on $11,000. Anything above $11,000, you pay at the highest tax bracket. So there was no longer an opportunity for people to take a trust of this magnitude and pay less in tax on that money. So they're most likely they're going to pay more, not less, if they're using an irrevocable trust. So that brings us then to state taxation, not federal. Let's take it out of federal context. Federal, it's not going to matter. But what are the implications on a state level? What was brought up, and I have to admit that I do see some validity to it, although I don't know the exact ramifications to the state, how they would interpret this, because you can see what can be done here. You have a trust that's set up in Nevada. Set up with a trustee in Nevada. So we have this gal right here. She's serving as your trustee. You're down here as the beneficiary of this trust. This. An irrevocable trust. You live in California. You're subject to 10% personal income tax on any money you receive. This trust, okay, it's not an asset protection trust, okay, mind you. So we're not concerned about asset protection. It's just set up as an irrevocable trust that we've set up for tax purposes only. This trust pays tax at 35% on the exchange. You live in California, you have this, you're going to pay 45%. Well, not quite that high, but pretty close on the exchange because you have state and federal taxation. You guys with me on this? So now the trust, because it's a Nevada trust held by a Nevada limited liability company, not you, we're going to move you down to this lower level here and make you a member in the LLC. The domiciles in Nevada The income's then taxed to the trust at the trust tax rates. You're not the beneficiary of the trust, the LLC is. Therefore, it's going to pay tax at 35%. No state income tax. So now, as a California resident, because the trust has paid tax on that money and it didn't distribute it to you in the year in which the income was earned, you have no income to report on your tax return because you didn't receive anything. It is the trust that paid the tax. Now, from there, what would occur? Next year, in 2011, what would this trust do with the funds? All the principal that's been after tax, it would distribute it down into the LLC. Let's assume we had $9 million after tax left in there. $9 million comes into the LLC. You control that LLC. That's no longer considered taxable income to you because it's after-tax money. It's already been taxed at the trust rate at 35%, the highest rate. If you're a California resident, that doesn't even show up on your personal income tax return because it's not income to you at that point in time. It's just a distribution of, like, for example, taking money out of your savings account. If you pull money out of your savings account, do you have to list that on your individual tax return? No, because they're after-tax funds. You just receive the distribution of after-tax funds, so there's no tax implication for you. I like it. I think it's aggressive, but I see the planning that went into coming up with this, and so I'm sharing it with you. Where the issues might lie with this strategy is if California would assess, or any state would, is that, you know, this trust was set up for one purpose only, and that was to avoid state income taxes. Therefore, it was a tax avoidance mechanism. So it's fraudulent, therefore you have to pay tax on that. See, just like the IRS, if they look at a structure that you created that was solely set up for tax purposes only, then if it's a tax-motivated transaction, they have the power to rewrite the transaction in any way they see fit. So in this case, if it was discovered, I would assume that the state of California might rewrite that whole deal. But, well, yeah, they would take that. But I do like the fact that you have an argument to thwart that and say, hey, you know, I set it up, yeah, also for asset protection. It just so happens it didn't work out in your favor. Therefore, I get the benefit from this trust. Well, that's another thing. The question was this, you know, if you lived in California, could you just change your residence to Nevada? And the answer is you can, but California is very aggressive, and they take the position that if you move to avoid taxes, they can still tax you on that money. Now, again, it's like everything. Can they discover it? See, in this situation, it's be difficult for them to discover because nothing's going to flow onto your 1040 or your California state return or any state for that matter, wherever you're located. You have state income taxes that will trigger that. So what's going to make them all of a sudden start sniffing around? I don't know. Maybe, you know, some filing eventually. But one of my clients was involved with Montana. They came after him for state income taxes. He didn't live there, but he had a house there. He could establish that he split time between California and Washington and only went there 2 months out of the year. They didn't buy it, and they hit him with a bunch of personal income tax. And now, you know, he asked me what to do. I said, well, fine, let him sit there with a judgment against you. You don't plan to live there. All your assets are protected. Not much they can do with it. So it depends on the state and the way they respond. Yeah. Oregon is with that because you have Washington right next door, so you're going to see that. But this is something I think it deserves some another look. It's something I'm going to look at next week. But those of you, you know, who are interested, if you live in a state that has an income tax, this might be a viable strategy if it's structured properly and it's set up in a state like Nevada and it's held in this manner. So you could potentially save quite a bit of money. Yeah. You got totally to protect you. Again, it's not my idea. That's why I have to look into it, but I wanted to share it with you because I do like the whole concept.
But that's only assuming you you add the short-term capital gain.
Repeat that again.
That's only
Is it on?
assuming,
Is the mic on?
it's only assuming you have a short-term capital gain.
This is only assuming I have a short-term capital gain. Well, you know, I forget off the top of my head if you have long-term capital gains in the irrevocable trust or not. I'll have to ask Steve that question. Greg, you're shaking your head. You do not. It's all short-term capital gains. It's all short-term capital gains in the trust. Tax rate. So, if you have long-term capital gains,
You don't want to do it.
you don't want to do it. You'd only do it for your short-term capital gains because you're going to be taxed at 15% on the other amounts. And so even with the state tax, you're in a lower bracket. So it'd be best to keep it outside. So this would be for those short-term gains. Yeah, it's kind of interesting. All right. So that's what the determination is. You know, can you find another way? And it really depends on where you're going. The deductions, of course, do not come with an LLC. There's no tax deductions there. I gave you the example of that trust, but everything else is post-RV. What are you going to do with your money? Because you're going to have a set of time from when you cash in to when you have to pay taxes within that same taxable year. So at that point in time, what you should look at doing is getting involved with a financial planner, somebody who has a tax background and can instruct you on investments that will produce tax deductions for you or tax credits. For example, oil and gas, working interest in oil and gas. If you ever thought about investing in them, I mean, that's something that seems to be making people a lot of money. My neighbor owns a jobber that redistributes gas, and he's got more money than he knows what to do with, so that would be something to invest in. Now, if it's in an oil and gas well, you receive the depletion credits that you can then use to offset your taxes. So you might have a tax liability looming at the end of the year for $3 million, but you made some investments with that money that have now reduced it possibly down to $2 million because of the investments that you made produced tax credits for you or tax deductions. So it's imperative that you get with a financial planner soon after the RV that understands, you know, this aspect of how to invest for tax breaks, because I think that in that first year, that's something you're going to want to do to preserve as much capital as possible. You should be looking at that. And there's, you know, I've heard people talk about, you know, buying, anybody here want to buy cattle? Want to set up a ranch? Okay. Ranching, I've been told that cattle, you can write cattle off on a working ranch under Section 179. You can depreciate the animals. So you go out and buy a whole bunch of cattle. Now all of a sudden, you just bought yourself a tax deduction with those animals. Why are you doing that? Because it's a tax deferral technique. I'm moving my taxes off to another year. So in a year in which the taxes are high, which is the year at RVs, by buying all these cattle now and depreciating them, that income gets pushed to another year when I sell them. So maybe I'm in a lower tax bracket at that time where you start selling them off over time. So just different ways you can approach the taxation of income that can benefit you. And one of the things somebody talked about, we talked about on the phone before, is investing in municipal bonds, taking that tax revenue, putting aside that 35%, maybe put it in some municipal bonds for the time being. That's tax-free money to you, and that can then be used to pay your tax liability at a later date. So, all right, so protect your family. So what do we do there? Well, I told you about this. You want to create a living trust for your family. I think this is probably the most important entity. Excuse me. The reason why is it avoids probate, and most importantly, it's private. One of the reasons why you create an LLC was for privacy. But as soon as you pass away, you're going to blow that privacy by allowing your estate to go through probate? I don't think so. Both sides of my family have been destroyed over probates. People have done certain things to enrich themselves at the expense of the family because they were in control and there were not adequate safeguards in place. And I can tell you, all that will do for you, your family, is tear it apart. And for many times, it's not about the money, it's about the principle. And so my father and my uncle did what he did. My grandmother's estate, 2 pieces of property, 5 bank accounts. I was the attorney that represented that estate because it was a natural thing. My dad, when my grandmother died, his mother, he said, listen, we're not going to go to Bishop, the attorney drafter. Well, we have Clint out of law school. I sent him. He works for free.
for whatever I tell him to do. Indentured servitude continues on, but now it's permanent retainer. Change words. He will handle this estate. And then in the third year, my dad would call me up and he would complain at me and say, what the heck are you doing? He'd use different words, but you know, the point's clear. He said, I'm not doing anything. It's what your brother is doing. I represent him, not you. And I cannot move him along. I can't force him to do anything because I work for him. And so my brother, or my uncle, took an estate that was valued at around $600 and some thousand and charged $75,000 in fees. It took 4.5 years to administer it. That is not what you want. Not at all. There's nothing to stop somebody from doing that because they're in control of the estate at that point in time. So I firmly believe that putting your assets out there in that manner just encourages or invites those types of disputes or those types of events. And so what I would do is create a living trust. I tell everybody I meet, you need a living trust. You don't know when you're going to pass away. My wife had 2 friends pass away this year in their 40s. They were standing here and the aneurysm hit them and they were laying on the floor. One of her good friends found this one individual, their friend of theirs, went to their house, picked him up in the morning. They're going somewhere, and there he was, just laying right there. He'd been pushing a television, they figured, into another room, and he died. One of them died, left some young children behind. Both cases, they were left behind chaos because neither one had an estate plan set up. And so when I deal with individuals on an individual basis, we always talk about the LLCs, and I tell them, I know that's important. If you had a choice, which one would I go for? I'd always go for the living trust because that's something that's going to be with you regardless of when the RV occurs. It's ensure that your assets, your dinar, are going to go to those individuals to whom you want to receive it in the manner in which you want them to receive it. I mean, one of the things we've been talking about is, do we want to give an 18-year-old 3 million dinar? No. So we were thinking about setting up an LLC. But if you don't, and you don't have an estate plan in place, and you passed away unexpectedly, you just gave them 3 million dinar. And they can do with it what they want. That's assuming they know what they have. And they don't just waste it because they think it's, you know, funny money or something like that because it looks different. So that's why I create the living trust, is to protect those things that you hold dear. Not to mention to ease the estate administration. When my wife's grandmother passed away, we did the exact same thing. We'd created a living trust for her. All of her assets were into it. And the aunt was named the successor trustee. 3 months she handled the estate. And her assets, my wife's grandmother, were similar to my grandmother's assets. She did in 3 months what my uncle took 4.5 years to accomplish. And that's why it's a no-brainer to me. People often say, well, do I really need a living trust? Well, it depends. If you don't own any property, you don't have any titleable assets, and you have cash, and the only thing in your name is liquid assets and some clothing, personal effects, and they total less than $50,000, yeah, you don't need one. But if you have assets, you have children, then you should have a living trust because all it's going to do is create chaos, I believe, in your wake if you don't have one. And the thing about it, this entity, what's so great is that once you create it, it's done. You put it aside. You don't have to revisit it unless your wishes change. Maybe one of your kids engages in a destructive lifestyle. Question is, do you have to record it? No, you do not have to record it. Once you create your living trust, you put it away somewhere. And then every time you buy something, a titleable asset, you take title in the name of your living trust. And that way you avoid probate completely when you pass away. I mean, the probate is such a scam that so many people fall prey to because attorneys perpetuate the myth that you do not need a trust until you have an estate that's valued at $6-7 million because they want that probate fee. When I worked for the prosecutor's office, I worked for 3 gals, and they were able to moonlight. And what they would do, they were allowed to engage in estate planning, personal injury, and divorce. I think they did those 3. Well, I know for sure they did personal injury and estate planning. One day at lunch, they're over there sitting at that table. I'm sitting at this table. They're talking. I'm listening to what they're saying. And I'm talking about a gentleman that came into their office over the weekend they drafted a will for, and they figured he had 2 years to live, and when they died, they were going to make, I don't know, $10,000, $20,000, $30,000 handling the probate on his estate. And so they were calculating how much money they planned to make. Now, my grandfather was an attorney, as I've already stated, for 50 years. He did one better. He was a marketing genius when it came to estate plans. What he did is when he drafted your will, he wouldn't let you leave the office with the original. He left you leave with a copy. And you did so willingly because he convinced you that's what you needed to do. The way he did it was slick. He'd bring his clients out. I'm assuming this is how it all went down. You look at him and say, can your house burn down tomorrow? Yeah. Could your house flood? Sure. What happens to paper when it gets wet or it burns? Okay, nothing's left. Could we have an earthquake? Absolutely. Doesn't happen that often. Would you possibly move and forget it? Because some people will hide it somewhere, or just you hide it in general and your kids could never find it. Yes, all those things are possibilities. So here's what we'll do. You see over here? These fire-safe file cabinets are flood-proof, fire-proof, earthquake-proof, and they'll always be here. That's the best part about it. So you can take a copy home, and then when you pass away, your beneficiaries can always obtain the original will so we can admit it to probate. You spent all this time, put all this energy into it, and this good money, why risk it to chance? And as a client of mine, I'll do it for free. Now, attorney never does anything for free, you know that, right? So what would happen is when those people pass away, kids get the copy of the will. They want to know where the original is. It says law offices of Curtis H. Coons on there. They went right down to my grandpa's law office. It says, all right, the probate just came through the door. Because they would leave having hired him to administer the estate. And then when he sold his practice, what he did is he added up all those wills in those file cabinets, and he told his associate, I will get a return of 75% on these, or 65%. The value of all these estates is somewhere in the neighborhood of this amount. You'll make this amount of money. I'm going to discount it down, of course, and I want so much money from you to buy those. If he wasn't going to buy them, he would have sold them to a different attorney because there's value in that. And literally, that's why attorneys draft wills for people. Is because of that retirement plan that they're creating for themselves. It's a constant revenue stream. And I go head-to-head with one of my good friends in Gig Harbor who's an attorney, and I say to him every single time, why don't you advocate trust? They're too complex for people to understand. What's complex about it? When you die, your kids have complete control of everything if that's the way you want it. They don't need you. It's when you bring the attorneys into the picture that things get complex, because they start messing the deal up and start planting seeds in your head. So I like to keep them out. And so that's why I tell people, avoid it. Create a living trust. Put all of your assets inside of it. What you have is this really big box right here. And this is what we call my living trust.
Are these all done with ledgers?
The living trust, no, you have to retitle assets. Ledgers come in with the LLC. So you would ledger your LLC into the living trust. So this is my, yes, yes.
A rental property that is inside an LLC. You'd ledger that LLC. Sorry.
Okay, grab that mic. Is it turned on? Yeah. Right.
Let me just ask a question. You know what I'm asking.
No, go ahead.
So if you have an LLC, then you just ledger it inside the living trust.
Yes, you do.
So the LLC holds the property, and then you ledger the LLC
membership interest into the trust. Correct.
Okay. Yes. You might want to explain that.
So what happens is when we create a living trust for many people, it is the LLC we first create, and then we finish up their living trust. So when we originally created this LLC, we listed the individual as the member. When we subsequently create their living trust, what we want to do is ensure that the living trust becomes the new member of their LLC in place of them. Because if we kept that LLC interest in their personal name, if they when they pass away, the kids, if this LLC is left outside here under dad's name, this asset will have to go through probate. So what we'll do is piece of paper, we have the member sign showing that they moved their interest into the name of their living trust. And now when they pass away, whoever's in control of the trust, let's assume their adult children are in control, they can deal with all the accounts. They have complete control over everything. There's no need for an attorney or to open up a probate. And so everything goes inside of here, your car, your house, everything.
So you would actually title the vehicle into the trust.
I would title the vehicle into the trust. I would go down to the DMV and change the title on the vehicle to the trust. So the legal owner becomes the living trust.
And that would be a taxable event. So like
Non-taxable event. This is all non-taxable here. It's a name change only.
in Washington State as well?
In every state, yes.
Okay.
Just a question in direct regard to this.
What happens, let's say you put your car in the living trust and you have a car accident. Now, does the trust and all of the entities within the, well, LLCs can't be pierced, but do your other assets that are in the living trust become subject to lawsuit?
Okay. If you have an asset in the living trust and you hit somebody with this car, you're personally liable. There's no way around that because you're the one that was driving the car. Now, is of all these assets inside of here at risk? Well, yes, to the extent that you can levy against them. For example, with the LLC, you know what the difference is here. They can't take that interest rate because of charging order. So a living trust does not provide asset protection. It's for estate planning. This trust becomes irrevocable when you pass away. We'll cover the details of that tomorrow about how this thing works. But this, I think, is the most important document you can create. So, not only does it protect you from probate, which can be very expensive depending on the state in which you live, it also reduces the state taxes. Right now, I mean, it does it by default is what I'm getting at. Right now, you could die tomorrow and you could pass on $5 million free of estate tax. Does that sound pretty good to you? Well, you want to die tomorrow?
Yeah.
Okay. Well, anybody else, does that sound pretty enticing to them? I don't think so. So for the next 2 years, if you want to die, you might as well get busy doing it. Okay, after at RVs, because you can move $5 million free of federal estate taxes. After 2 years, it goes back to $1 million in 2013. And then it's going to jump up, and you're going to pay taxes on everything above that. So what I want to show you is what are the devastating effects of the estate tax from a wealth confiscation standpoint. That is, what would it cost to cover your estate tax? And if you looked at this in terms of only a $2 million estate, and you plan on living for another 35 years, and that's the size of your estate, how much would you have to take and put aside in a separate bank account just to cover those estate taxes that will be levied against you when you pass away on a $2 million estate, 35 years?
So if it's in a Senate trust, it's not taxable.
Hold on. $750 a month. If you get 3% annual interest, net you'll have is $550,000 because your federal estate tax on a $2 million estate is going to be $550 grand. $550,000. Now, what do we call that? Well, not as it rest in peace, we call it this. Big rip off is what it becomes. Okay, it's the death tax. Now, with a living trust, you automatically take each spouse and you say, you have $1 million you can pass on, or you have $1 million, or if it was $5 million, you have $5 million, you have $5 million, and it utilizes their exemptions amounts to ensure that you can pass on the most amount as possible free of any federal estate tax, rather than what has been done in the past. Everybody leaves it to their surviving spouse. Surviving spouse then passes it on to the children, and they incur a tax liability where they did not have to incur a tax liability because basically they're doing this. They're putting their head in the sand. When it comes to estate planning, too many people approach it that way. It's not a concern of mine. So living trust does a lot from a tax standpoint. This is by default. Every living trust that's, well, assuming that the attorney knows what he's doing, is set up with these types of tax saving provisions inside of them. You can do the same thing with a will as well, don't get me wrong, but you get to go through probate if you want to do that. And remember I talked about having property in multiple states, you have to do multiple probates? You got assets in trust, there's no probate in any state. So there's another benefit there, you avoid all these multiple probates. All right, so putting it all together, what does it look like? It looks like this. You create an LLC for your currency. This is a Nevada LLC for my dinar. I've drawn this out many times now. LLC for real estate in the future. maybe multiple LLCs for real estate. And then you create a living trust, just like this. And inside of here, you might put your personal residence. Now, we'll talk tomorrow that you might want to consider if your house is paid off using an LLC for your house in limited circumstances. You put in here your cars. You go inside of there. Your personal bank account would go inside of your living trust. That would all be inside there. So any personal types of assets would go in your living trust. Now, after the RV, if you're going to set up a corporation, your corporation would be owned by your living trust. And you would make your corporation typically the manager of all of your limited liability companies. So if you set up a corporation, you'd want it to manage your LLCs. One of the things we'll talk about tomorrow is what we call income streaming or upstreaming of income. By having your corporation manage these LLCs, you can pay management fees up to this corporation. Now you have management fees coming up to the corporation. What is it going to do with that money? It's going to spend that money. This is your corporate headquarters. You came here from Washington. So if you have your corporate headquarters here because this is where you created your business, your trip now becomes what? Deductible. So you find ways to write off expenses that ordinarily you're paying for in a non-deductible manner. So that's why we would put that corporation up there as an income stream. So this is, you know, what we're going to be talking about in detail tomorrow. Questions often arise. We got a lot of questions. I mean, I know we've set up quite a few for people in here. They're entities, and pricing always comes up. What do we charge? Because we do set up entities. Here's what we charge. If you want to file your entity, because we have people that are in different situations. If they just want to get it filed, we charge $550 for filing only. What does that mean? Well, we've filed a number of LLCs for people where we filed with the state, we get it all ready to go, we put together initial draft of the agreement, but we don't send it to them until after the RV. And at that point in time, we charge them the difference remaining on the balance to finalize the LLC. So it gets them basically in line, because when at RVs, we have a lot of LLCs we have to set up. That's $550. That includes the filing fee. But with a problem with that situation, if you go that route, and some people have now realized this, you can't gift. There's no asset protection because your dinar is not in the LLC at this point in time. All of that comes later because we don't obtain your taxpayer identification number on that filing only until we actually draft the operating agreement. That's when your business is created. So we don't even get an EIN. So we can't go down and do all the other stuff that you should be considering. But for many people, you know, this is where they want to start, just to have their name. We set it up with the nominee, so you have the business suite here, the resident agent. It's all done. It's a Nevada entity. It's just turning the switch. And so those people kind of like, I would use this, got in line. Okay, so the first one's out the door once the RV occurs, and then we just bill you for the difference after we send it to you. We also have, we had a question? The difference, this is what I'm going to show you now. We also, if you want us the full service LLC, that's going to run you $23.95, and that includes the filing fee. Now, what is that? It's a Nevada LLC. What does that include? Well, we file your LLC, we get your taxpayer identification number, we then draft your operating agreement, we ledger your dinar into your LLC, we draft all your we fill out your stock ledger, we draft your units, issue them out. If you want to gift, we draft all the gifting forms for you to gift your LLC interest to somebody else, and we send it all to you for you to sign. We provide you with the nominee, with the address suite here. We give you the choice of banks that you want to work with, Bank of America or Wells Fargo. We will contact that bank and start the banking relationship for you, and then you'll take it from there. That's if we're doing all the work for you to complete that limited liability company. So in that case, when you get it from us, like the individual I met yesterday who drove in to pick up his limited liability company, he just sat down, and I showed him the LLC, and there's a bunch of little flags on there. said, what are those? So you know what I'm talking about, right? They're little flags, okay, because he's received our LLC. And what it says is sign wherever there is a flag, and then send us back those signature pages. Now, if you call us up and you say, what does it mean when it says sign here? We have one response for that. Send me back the LLC operating agreement because you're not ready to have an LLC yet. And that's happened a number of times. But anyways, we make it so you don't have to do anything. And so that's the full service route. So this is the beginning, and then it morphs into the full service. We also had people asking us, and I'm saying this not for your benefit, for people on the call or on the internet. They've asked us, what else can we do? We also offer a service that's in between this. It's it runs you $9.95, and this is where I'm going to call it a kit, but it's more than a kit. With this particular program, we give you the operating agreement and the forms. You can complete them, but we perform your filing for you. So we will file your entity. We will obtain your taxpayer identification number. You will receive the nominee and the business suite for the year here. So the mail gets forwarded to you. But you have to do the legwork in drafting your operating agreement and issuing out the interest. People that have opted for this, we also, they become a platinum member. We charge $35 a month for support. Some of you may know, for all of our clients. What does that entitle them to? Questions. They can ask questions of Greg, myself, or the other attorneys in the firm. So that's an added benefit they have. So that helps them along the way. And we put on webinars on occasion to walk you through. So if you had questions about filling out your LLC, we'll do a follow-up webinar. And you can log in and we'll go through how to set up that limited liability company. But it also gets you access to the web where you can watch videos that I've done where I've walked people through it. So it's kind of that in-between place. People who want to get their information set up earlier, but they can't afford the full service route. We came up with this where they do a lot of the work themselves. So it's not a customized LLC, but it is one that's set up specifically for the dinar. So if you wanted different voting rights and things of that, it's not going to happen. But what it's going to give you is the ability to create an LLC with a nominee manager. That's the way it's set up. So you're not listed. It is set up specifically for the dinar. You're in control of the LLC. You can gift it away, and as long as you don't gift away more than 85%, nobody can tell you what to do. And we give you the gift forms and all the documents on how to do it. So that's an in-between phase. Yeah.
What if you already have a Wells Fargo account set up just for dinar with the number that they've asked for?
Yes.
So they can send the money, wire the money into?
Mm-hmm.
And also, I already have a living trust. So would the living trust have to be redone, or could I keep that? You said to put that in LLC?
Okay, question, do you have to recreate your existing living trust right here if you set up an LLC? No, not necessarily. If you're a client, we ought to review that, take a look at your trust. Most of the time, I find that trusts do not need to be redrafted, that they're okay. What is particularly different, though, possibly with the dinar, is that your desires may change. And that is, now that you have a lot more money, you may want to have a bunch of other people you want to distribute money to or dinar to. So what you may consider in your living trust, if you redrafted it, is you would say this, that if the dinar has not RV'd by the time I pass away, I want the following people to receive the following amounts of dinar. Okay, if it has already RV'd, then the following section will handle the ultimate disposition of my estate, and you may divide it up differently that way. So if you wanted to change your distribution plans, then yes, you would probably redraft your living trust. The trust, we charge $1,500 to draft the living trust. Will prices go up after the RV? People have asked me. They will slightly go up, not probably $500 you'll see, and the reason why is because I fully expect to be working 18 hours a day trying to make sure that people can get their documents set up and out so they can get funded, because there's just a lot of people that have been calling me and saying, Clint, I expect you to be available for me. And yeah, all right, I'm an attorney. I'm going to make money doing that. That's what attorneys do for my work. I'm going to be upfront with you on it. And so there's an incentive for me, but there's a lot more work that's involved at that point in time. So there is a benefit to doing it early if you're already done.
It's my understanding that once we have an initial LLC, for example, I did the full service package, but the platinum service is only free for 1 year, correct?
Platinum service is not free. It's $35 a month.
No, for example, with the full service
Oh, with the
LLC.
boss service?
Yes.
That's included, yes, for the first year.
Right.
And then each additional year, it's going to run you $695 to maintain the boss service.
Got it. And for any additional LLC after the first one, you only charge
$1,500.
$1,500.
$1,500 for the additional LLCs that we create. And, you know, it just depends on why they're being created, because we have different operating agreements for different types of situations. If it's for real estate, then it's a real estate operating agreement. If it's for a dinar, it's going to be a different operating agreement. So we have to see what you're doing. And that's why we consult with people that come to our events.
I'm sure I've heard you answer this before, but is there anything that we must do prior to the RV, or is everything just prior to cash in or exchange?
Anything you must do prior to the RV. If you want to run your money out of your name, you don't want it to run through your personal bank account, and you must set up an LLC before the RV. That's what I would do, because I think after the RV, depending if what I've been hearing about those denominations with the 20 larger notes, if there's a time limit, have you guys heard this as well? It goes back and forth. Well, if you want to exchange your money right away, and you don't want to go through your account, then you should have an LLC set up with a bank account ready to go to accept that. And here's why. After the RV occurs, is your life going to be more complex? Absolutely it is. So it's just one less thing that you have to deal with after this RV occurs, because you're going to be considering, where am I going to place, not only where is the money going to flow into, but what's going to happen to it when it flows into there. And so there'll be tax questions, reinvestment questions, paying off debts. So this is one aspect that you've just already taken care of. So from that standpoint, I would say it should be set up beforehand. If you want to gift anything away, it should be set up beforehand if you plan to gift. Otherwise, you won't be able to do it in the manner I described. It'll be an after-tax gift or an after-RV gift through the LLC. Therefore, you'll be subject to gift tax at that higher rate. So that's an issue that comes into play. So I often tell people, if you want privacy, you want to minimize your gift taxes, and you want asset protection before it RVs and immediately after, then I would go that route. Because you just can't predict when harm's going to hit. We have a client in Oregon. She wouldn't get us her LLC questionnaires back because she couldn't decide on a name. Hey, you laugh, but that happens a lot. People can't, the husband and wife, husband says, I want this name. That's a dumb name, the wife will say. And so they go back and forth. We called her up. We asked her for those questionnaires. We're still debating. We'll have them to you in 2 weeks. Well, the following week, she was on I-5. She stopped because there was 4 cars piled up in front of her. She stopped with about that much room to spare, she tells us. A car plowed into the back of her Mercedes and propelled it into the car in front of her, and she was at a dead stop. And then that car got hit and so forth. Who got sued?
Everybody.
Who got really sued? Our client, because she was the one that had all of the deep pockets at that point in time. And so they went after her. And so it took our planning and created some problems for it at that point in time. Because the question is, were you creating this plan now after the harm occurred? And so I told her, I said, well, we could still go forward with it because we could argue that it started before you got in the car accident, but that just added some extra oomph to get it going a little faster. And so from that, you know, if you're concerned about asset protection, I would. Mine's just simple. I already know it's done, so I like that peace of mind. Don't have to worry about things.
Another issue is you're going to have a million people rushing to have them done after the order.
Oh, it's a great point. You're going to have a lot of people rushing. Yeah, I mean, if you want to use us, we're going to be extremely busy. And so for those people that we've already started on, I mean, they know they're going to get their work done immediately. We've already told everybody that. And so that's an added benefit. I mean, you've seen our docs. Have you had an LLC prepared by anybody else?
I've had a living trust done. It detailed pretty well, but no, the LLC, I have friends who have LLCs.
Hold on, we got to get that one on thing. And what was that again?
Actually, I have friends who have had LLCs done elsewhere. They don't even compare. They don't even compare. I did have a trust done elsewhere that was fairly good, but the LLC is by far superior to everything else I've ever seen.
Yes, because that's what we do. It's all we do is just asset protection. So that's why people come to us. All right. A couple announcements. Today hopefully is going to, today was kind of a mess technology-wise in this room and our other office. Tomorrow I expect everything to run smoothly. So those of you out there on the internet, thanks for bearing with us. I think we've hopefully ironed everything out. It sounds like we have, based from the nods from Greg and Steve. Because of the problems that happened today, and even for you guys, because it disrupted you, we were supposed to start at 1 and end at 5, and now we're at almost a quarter to 6. I'm going to take this and I'm going to put it on DVD. And everybody that was on the call or was in the room, I'm going to send it out to you as soon as I get it authored. You'll get this presentation on DVD so you can watch it later as well. So you'll have that. And I'm going to put on there the webinar that I've done previously. That's also going to be put on there so you have that information as well. And so we'll get that out to you. I don't know if I'll be able to get it out next week, probably the week after, because I'm going to have to get it authored and then burned and everything, but it will be coming, so you'll have that. So here's what we're going to do. We're going to start up tomorrow at 9 a.m., and we're going to go through these entities in detail starting tomorrow at 9 a.m. Pacific time. So that's, depending if you're on the East Coast, it's going to be noon your time, and we're going to run until approximately 4 o'clock tomorrow Pacific time. So that's when we'll end. We'll take an hour break or 45-minute break for lunch. And then we'll, probably around 12, 12:30, and then finish out the rest of the day. So if you're planning today, that's how it's going to happen. All right, you're free for the rest of the evening.
So do you have you're not typically here in Nevada?
I'm not. I'm typically in my Seattle. I'm a Seattle office, Tacoma office. Yeah, not here.
Because what I'd like to do.
We have a lot of attorneys here.
Right. What I'd like to do is just come in with all of my stuff.
Yep.
Sit down with somebody and
Absolutely, we can do that. Good. Perfect.
Yeah, that's what I want to do.